I'm going to tell the officer.
Hey, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, February 12th, 2026. Happy birthday, President Lincoln. Happy birthday, Uncle Larry. We have 9 bills on the docket. We're going to start off with the Vice Chair with Senate Bill 297, then we'll go to 345, then we'll skip back up to 511. And then we'll go to 462, 463, 477, 480, 487. And with that, Mr. Vice Chair, welcome Senate Bill 297.
Thank you, Mr. Chairman. We have passed this bill previously, so it will be familiar to all of you. And it's a very straightforward bill. As many of you know, when manufacturers interface with their local car dealers, which we all represent here in Maryland, they have a minimum advertised price. And they give money to the dealers to advertise. And so I think perhaps my advocates may disagree with it, but I am totally fine if someone gives you money and restricts your use of that money. The question in front of us is not about minimum advertised price. The question is whether basic listing of a vehicle's prices on a website constitutes advertising. So right next to me is Rob Smith. He represents the incredible Fitzgerald dealerships. And they're on television all the time, and they use the manufacturer's money to go up on television, and it's appropriate that they respect the manufacturer's requests. But simply putting an actual price of a vehicle on a website is very much different than a commercial that airs on your television or comes up on your phone. When you go to a website to research a vehicle that you want to buy, it's not a lot to ask that the price of the vehicle, the actual price of the vehicle, is there. And under current law, the dealers cannot show that to you. And that's why that dance that you guys have done is required. Hey, how much is this car really? And then they're allowed to email you what the price is. They're just not allowed to put it on the website. The difference between a website and the email is unclear to me. So this bill, which we have passed previously, would simply clarify that an actual sale price on a website does not constitute advertising and can be done within the confines of our current law. Just so you know, this doesn't require dealers to advertise their actual price. If for some reason a dealer wants to go by the current rules and restrict themselves in advertising the actual price, they can continue to do so, either because they wish to or because their relationship with their manufacturer is such that they want to continue doing that. You've noticed that we've changed the title this year to honor Jack Fitzgerald. Mr. Fitzgerald, who many of you know, was a longtime advocate of transparency and pricing in his industry, and we will miss him, and we want to honor him with this legislation. Thank you, Mr. Chairman.
Good afternoon.
Come on up, Rob.
Oh, up here. Thanks. Good afternoon, Mr. Chairman, Mr. Vice Chair. Thank you for sponsoring the bill. My name is Rob Smith, and I am the president of Fitzgerald Automalls. I appreciate the opportunity to speak in support of the bill, SB 297. The bill addresses a simple reality. The way consumers shop for vehicles has fundamentally changed. For today's buyer, the dealer website is the showroom. Most consumers do their research online and often visit only one dealership after they have already made their decision. In that environment, the online price is the most important price in the transaction. Under manufacturer minimum allowable advertised price, MAP rules, dealers are often prohibited from posting the real selling price of a vehicle online. In many cases, dealers are required to show prices that are higher than what they are actually willing to sell the vehicle for. Dealers are also prohibited from explaining that these higher prices exist because of a manufacturer rule. That's all this bill addresses, is the explaining. Manufacturers often say that dealers can disclose real prices in a one-on-one communication, but that does not reflect modern consumer behavior. Many consumers are unwilling to provide personal information simply to learn the truth about price. They want transparency before engagement, not after. Ironically, in a physical showroom, dealers are allowed to display any real selling price they choose on a vehicle's windshield. But in the online showroom where consumers actually shop, those same prices are prohibited. When dealers acknowledge or violate MAP rules, manufacturers can retaliate by reducing marketing assistance. That raises dealer costs, distorts competition, and ultimately harms consumers. SB 297 is a modest balanced bill. It does not set prices, it does not prohibit MAP programs, or require any dealer to change how they advertise. It simply allows dealers to truthfully disclose that a manufacturer-mandated price exists and that a lower price may be available. This bill modernizes the Maryland law to reflect how consumers actually shop today. For those reasons, I ask for a favorable report.
Hello, my name's John O'Donnell. I'm the president and CEO of the Washington Area New Automobile Dealers Association with more than 220 dealers as members. We go through an internal auditing process to see whether or not we would like to support legislation. We support this legislation. Thank you for your time. And Senator Waldstreicher, thank you very much for helping us with the standing bill, which is our priority bill this year.
Excellent. Questions from the committee for the sponsor or his panel? All right. Seeing none, thank you all very much. Good to see you all. That'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel with William Kress. Bill, there you are.
Thank you, Mr. Chairman. Members of the committee, my name is William Kress. I'm here today on behalf of the Alliance for Automotive Innovation. I think the sponsor and vice chair did sum up the issue. We set minimum allowed advertised pricing because we share advertising funds with the dealers. And so the purpose of that is to set all the dealers on the same level playing field. And if you do that, you're entitled to the advertising dollars. So, you know, this bill has been here a couple times before, and something new popped up today that I should address. What is the real price of a car? If you've actually been into a dealership and seen what the real pricing of a car is, it doesn't happen until you get into the finance and insurance manager's office and you have the offer sheet. So it is the listing price of the car. It's the trade-in value that's negotiated once you get into the showroom. It's all of the markups. It's the financing. It's the markup the dealer gets on the financing. It's all the extra add-ons that the dealer wants to sell to the consumers. And it's up to you to decide whether those are good or not. You want the gold premium warranty, extended warranty? Do you want the silver? Do you want the bronze? Do you want the nitrogen in the tires? Do you want all the add-ons? Do you know how much the dock fees are? Do you know how much title and excise taxes are? Do you know how much the registration fees are? All those go into what the real price of a car is. So to suggest that putting a notice on the website that they may be able to sell the car for something lower than the minimum price allowed by the manufacturer, it's really not helpful to the consumer. Because if you see that on a website, you'll have the idea that, in fact, you might get a great deal. And perhaps you will when you go in. But in fact, what the dealers want is to get you into the showroom, not to sell it online. They want to get you into the showroom, get you there for 3 or 4 hours, and go through the add-ons and make their profit. And I support that and I understand that, but this is not a consumer protection bill.
All right, thank you very much. Questions from the committee?
Thank you.
All right, thank you very much. All right, with that, that'll conclude the hearing for Senate Bill 297. We'll now move on to Senate Bill 345 with Vice Chair Waldstreicher.
Thank you, Mr. Chairman, members of the committee. As was referenced earlier, Senate Bill 345 is the priority for the 2 dealer associations that are in the state of Maryland, the Baltimore region, as well as the DC region. I had the good fortune of going to the car show in DC. It was a lot of fun. 10 states allow for dealer standing in their states. So the way it works under current law is that there is an administrative process when there is a conflict between the manufacturer and the dealer. They go to the MVA. The MVA is the administrative process, kind of like how in other circumstances the Office of Administrative Hearings might be. So it's not a judicial process. But if there is some conflict between a dealer and a manufacturer under current law, they go to the MVA. Sometimes these conflicts are universal. They go across manufacturers and they go across dealers. In that case, it's appropriate that there be association standing at the MVA. So Like I mentioned, 10 states have this, and all of you who practice law are familiar with this in the judicial context. Here's an example from our own work. As many of you know, a few years ago, we passed an advertising tax on social media. And the people who sued the state of Maryland in order to overturn this law, it wasn't Facebook, it wasn't Instagram, it wasn't Twitter, it was the association of all those social media, and they won their case. And it was appropriate, because it affected all of them, that the association received standing to litigate that case. This is analogous, where there is a universal concern that is across manufacturers and across dealers that deals with our state franchise law. The dealers should be able to be represented in the administrative process through their association. With that, Mr. Chairman, I'll ask for a favorable report on Senate Bill 345.
Mr. Chairman, members of the committee, my name is Peter Kitzmiller. I'm the president of the Maryland Automobile Dealers Association. We represent 300 franchise new car and truck dealers and their 20,000 employees here today in support of Senate Bill 345. Association standing provides a practical solution to enforcing these franchise laws. I've been president of the association 28 years. I've been in this committee more than half of those years doing franchise bills with the manufacturers. So what this bill basically allows for is the association to sort of stand in the shoes of an individual dealer. While the law certainly allows for an individual dealer to sue their manufacturer, practically in the real world, this is very difficult to do. The manufacturers have control over the allocation the dealer receives, programs. They have control over a lot of aspects of their business. Their partners, they're reluctant to sue, which results in many cases in practices that clearly violate Maryland law not being addressed because an individual dealer just doesn't have the ability to sue. This bill would address that concern. This bill does not create new rights. There's no new violations or any new regulatory authority. It only clarifies who may seek judicial review of laws already on the books. As Senator Wallstrecker mentioned, 10 other states have this. I think it's telling in the manufacturer's written testimony, they don't mention the fact that they've had problems in those states with increased litigation. There is not increased litigation in any of those states. It's just simply gives the association the ability to address systematic problems. We are not going to get involved in individual contractual disputes that one dealer may have with Mazda or whatever. This is a systematic problem that we would be able to address. It would also, I think, cut down on the necessity to come back year after year with franchise bills in order to get these enforced. With that, I'd ask for a favorable report.
Thank you, Mr. Chair, members of the committee, Bill Castelli, also on behalf of MATA. And I'd like to just address some of the concerns that have been expressed in testimony as well. One of those concerns is that this overturns kind of statutory or case law in Maryland, and that the standing rules have been sacrosanct. And the truth of the matter is this legislature has made certainly a number of different changes to standing law in Maryland, granting community associations and other associations the right to stand in the shoes of a member of that association. We did it in 1978 with the Maryland Environmental Standing Act. We've done it in the late 90s and early 2000s with community associations for nuisance law. We did it as early as 2010 as well on other Maryland environmental laws. So we think this really bestows to the Dealers Association in the same way that she was bestowed it on other associations, those rights. Also, there's been some discussion of damages and what damages are worth. This is really only to an administrative hearing seeking clarification on franchise law. So it doesn't allow damages. The original bill that passed out of the House committee and on the House floor 134-0 removed all of those damages. So this is just on the franchise, getting a hearing on those franchise issues. And again, as they said, 10 states allow it. There are some of those states, at least 4 of them, that do contemplate damages, but this bill does not go that far. So it's just for those franchise rights. And with that, we would encourage a favorable report.
you, Mr. Chair. Mr. Kitzmiller,
Yes.
can you give me an example? Just an example of what would be?
Sure. So probably 10 years ago, there was an issue in the automobile industry, especially with luxury vehicles like Range Rovers and Porsches, where
Oh, things I don't drive, yes.
where a customer would come in and purchase the vehicle from the dealer, and ultimately they were purchasing for the purposes of exporting it to Eastern Europe or to some other market, which causes significant problems for the manufacturer with warranty, et cetera. They had a right to be concerned. What they were doing, however, is if in fact a vehicle was exported, they were charging the dealer back all the profits they made and then telling them that we're not going to give you any more vehicle allocation. We came to the General Assembly, actually worked with the manufacturers on that issue, and we came up with a law that basically said you can only charge the dealer back and withhold allocation if at the time of sale the dealer knew or should have known that that vehicle was going to be exported. Because we would have somebody come into the dealership and buy the car with an address in Ocean City, Maryland. We would pay the tax. He would pay the tax. We would remit it to the state. We had no idea that that vehicle was going to be exported. So that law was passed. Again, we worked with the manufacturers on that because they have a legitimate concern there. 2 months after the bill went into effect, Porsche of North America sent a letter to all the dealers telling them basically, you get one bite at the apple. One car gets exported, we're not going to do anything, but on car 2 through however, we're going to penalize you. I sent them a letter saying, nope, the Maryland General Assembly specifically said that we have, unless we knew or should have known at the time of the sale that it was going to be exported, there's no penalty. They ignored it. An individual Porsche dealer is not going to go to MVA and file that complaint and go in front of the administrative law judge on that issue. Again, I'm not saying that's just an example where that would be, an individual dealer. It's going to have to be pretty dramatic circumstances to file a complaint and to go into the administrative law judge against their manufacturer. And so these laws, the law's not effective if you can't enforce it. We have an extensive franchise law. All 50 states have it. This is just an attempt to make sure we can enforce it. It will be done very, very rarely. I can tell you as the president of the Maryland Auto Dealers, we do not have the financial wherewithal to be filing multiple lawsuits on a yearly basis. This would be a last resort, basically.
Okay, thank you. Thank you, Mr. Chair.
Excellent. Further questions from the committee? Senator Sidnor.
Thank you. You had just mentioned all the other 50 states and their franchise laws. I'm curious, does something like this exist in any other states where an organization like yours?
10 other states have a dealer association standing. It was 9 when we put the bill in a couple of years ago. New Jersey passed it last year. I think there's an effect now, but there are 10 states that have dealer association standing, yes.
I appreciate it. Thank you.
Similar to that question, for the 40 states that do not have a dealer association standing, how are they operating? Are they all similar to Maryland, or are they widely different?
So I'd say most of them are similar. Some of them, instead of the Motor Vehicle Administration like Maryland, which adjudicates these kind of things, they have a Motor Vehicle Commission. Some of them don't have either one. You just simply go to whatever their initial circuit court or whatever they call it in their particular state. So some states have Motor Vehicle Commissions that do this. A lot of states do it through, we call it MVA. Most of them call them the Department of Motor Vehicles.
And then in these cases, the way it works currently in Maryland, as the bill sponsor said, MVA is, would you agree that, because I don't know, is MVA sort of acting the way we would understand the administrative, act works or the agencies work? Do they have a hearing in which testimony is taken with some looser standards for evidence and whatnot? You probably don't need a lawyer or not. Just what is the process?
So there was a change. I'm not sure on how MVA decided to proceed with these cases. I think it was maybe 20 years ago. They originally, if you are a licensed entity Under MVA, so as a dealer, you have to be licensed. As a manufacturer, you have to be licensed. If you had a complaint against another licensed entity, you would go to MVA. You would simply go to Glen Burnie. There would be a sort of an informal proceeding, and then you would go from there. Now, the way it works is you file a complaint with MVA. They send it straight to the administrative law judge, and you go through that process. And you do need a lawyer. And then you would go through that process.
Okay, so I think I misunderstood the sponsor. So now it is truly an administrative proceeding.
Correct.
Is that correct? Okay. And then therefore, you can take an appeal, I assume, to the circuit court if you're
I believe that you
agreed.
can, yes.
Okay. And I don't know, does this bill anticipate both the dealers would be able to come in as an association and the manufacturers could come in as an association? Like what's good for one is good for both. In other words, I guess two associations could constantly come in and everybody could spread the cost around.
The bill, I think, as written specifically talks about dealer associations. I would have no problem if we wanted to change that to include the manufacturer association.
And do you know whether the other states do it that way? Like, in other words, they opened up that broader.
I will double check. Okay. I don't believe they do, but I will double check and get back with you on that.
All right. Thank you, Mr. Chairman.
That will conclude the testimony for the proponents of the bill. We'll now switch to the opposition power. Mr. Kress.
Thank you, Mr. Chairman, members of the committee. William Kress here today on behalf of the Alliance for Automotive Innovation in opposition to Senate Bill 345. You have heard this bill before, and it is a radical departure from case law. Typically, with standing, you have to be an aggrieved party to bring a case, or you have to have privity of contract. This would overturn that. It is an administrative proceeding, and as such, it would act as a shield for the dealers because we are limited to interrogatories and discovery. And so what we would glean from sending interrogatories to the association for the dealerships is unclear. Really, what you have to get to is the alleged aggrieved parties below that. This bill would act as a shield, and I would find that say that it's improper. With respect to whether or not the dealerships would pursue a case at the NBA, I just want to point out that these are very sophisticated corporations, multi-billion dollars with a B. Most of them are publicly traded. Most of them have general counsel. I have not heard of a case where a dealership was afraid to pursue an action at the NBA. That is simply not the case. And so for those reasons, and frankly, you're going to be opening the door for other associations to come in and ask for standing and be dealing with this issue year after year. But for those reasons, I would ask for an unfavorable report. Thank you.
Is there any prohibition against a dealer going to the association and asking for assistance with counsel? In other words, the could be a protector of them in the sense of, association can act any way they want. They could collect money, and if the dealer had a particularly big case that might have some precedential value to, they would be in the position if the association wanted to, like I'm thinking like when you have insurance, an automobile insurance, they come in and they offer you counsel.
I'm not aware of any prohibition through the franchise agreement. I assume that they can do that. They want to do it informally.
Well, because I'm trying to get at their concern is that there's perhaps a fear. I hear you saying there isn't a fear to bring it. They're sophisticated. They have resources and whatnot. And then I guess the other thing they would say is they feel like there's a disparate positions of the manufacturer being even bigger than the dealership. But my thought is an association of dealers has plenty of resources that they could voluntarily, without us changing the law at all, be of assistance to any particular dealer if the case and the matter was of interest to the universality of the dealership association.
Yeah, so I have no doubt that Mr. Kitzmiller does a great job working for his members and works through our association as well. But when I say that these dealerships are sophisticated, AutoNation, big dealership in Maryland, $26 billion in revenue. Fitzgerald, a little bit smaller, $1 to $1.5 billion in revenue. Group 1, $17 billion in revenue. So they're large corporations, many of them publicly traded.
Okay, thank you.
All right, additional questions?
Yeah.
Oh, Senator Sidnor.
Thank you. So earlier, it was testified there are about 10 other states that have these. You said that these types of laws would be used as shields. Have you seen that occur in one of these 10 states that has?
So I have not reviewed the other state statutes. I don't know what they provide. I would point out that this particular bill doesn't limit it to injunctive relief. I don't see any prohibition on damages. And I'm not familiar with the process in the other states. I can tell you that if you're going before an administrative law judge, discovery is very limited.
Okay. Thank you.
Yeah, Senator Muse.
The numbers, can you go through the numbers again of what they make? I think you went through those numbers.
So the list that I have in front of me is AutoNation, 26 billion, Group 1, 17 billion, Sonic, 14 billion, Asbury, which is part of Coons Group, they did 14.8 billion. Mile 1, 3.5 billion. Sheehy, 2.4 billion. Dark Cars, 2 billion. Bahanka, 1.8 billion. So big corporations.
That's a year?
Yes, sir.
I'm in the wrong business.
I think we all are.
Yeah.
All right. Senator Fulton.
We're going to open up a car dealership.
In the 10 states that allow for this, are you aware of any abuses that are occurring or have occurred?
Again, Senator, I did not look in the other states.
Okay, that's all. I just
Yeah,
wanted
if I had my association person here, they could tell you, but I
Okay.
don't deal with other
All right.
states.
Thank you.
Excellent. Further questions from the committee? All right, thank you very much.
Thank you.
Thank you, Ms. Kress. All right, with that, that'll conclude the hearing for Senate Bill 345. We'll now move on to Senate Bill 511, and Senator Sidnor. Yep, Senator Sidnor will take the chair. Tie my shoes. Hey, how are you? Good to see you. All right. Hey, how are you? Good. How are you? Good to see you. See you, Ryan. Thanks. All right. For the record, Senator Smith here to present Senate Bill 511. Panelists up here, but before I start, I want to recognize and thank my cross-file, Delegate Laura Charkoudian, who's helped lead this issue for several years now. Also, we've got some constituents that are going to be on the panel and here behind us, Judy Treble, Shasha Olenek, and Alan Clark. Also, I want to thank Bill Carson from the MSBA, from the Committee on Corporate Law, Dan Ehrenberg, Patrick Jenkins, Ellen Zerbrig, Ann Seacott, Doug Ryan, Colby Sledge, and Ryan Gadsden, who have all been consulted and have helped us create this legislation, or this version of the legislation before you since last year. We passed this bill last year. You might remember this is the Limited Equity Housing Cooperatives bill. And before I get into the mechanics of the legislation, I want to just kind of set the stage for why I believe this is necessary. In this committee, we have endeavored to balance protections for renters and also incentivize people to come into Maryland to build housing. That's kind of been our perennial struggle in this committee. And I wanted to cite a couple of things, or a couple of reports. One report is the Comptroller's report on housing and the economy, in which she cites that from 2010 to 2023, Maryland saw 2.3 million residents move to other states. And that's in conjunction with, we've had 2 million people move in as well, but we've had net out migration. The report also states that in Maryland, we're facing a housing shortage of close to 100,000 units, and that we'll need to build 590,000 units to meet our housing demand by 2045, which is the projected growth of our population to meet that demand. So we are woefully inadequate with respect to our housing stock. We need to build more housing. Also, in that report, it shows that since COVID-19 in Maryland, housing prices have gone up 60%. And the largest portion of people moving out of Maryland, that net out migration, are people from 20 to in their mid-40s. And the biggest reason is because of housing costs. So we're losing a lot of population. We're losing a lot of talent because of people moving out because they can't afford to live here. Nationally, a new report just came out that said the first-time home buyer, do you know what the age is for a first-time home buyer? It's now 40 nationally, 40. That is up from age of 28 in 1992. So we have a woefully inadequate housing stock in Maryland. Housing prices are too high nationally and in particularly in Maryland, and it is the driving cost for, or the driving reason for us experiencing our net out migration for young talent who are drivers of our economy and our tax base. So the bill before you actually takes a different meaning in this context. I didn't explain it this way last year, but I think when framed this way, it actually makes this bill more compelling and more urgent to have. Because as we look at affordable housing options, and we'll have more bills from Senator Muse later on today to protect tenants, limited equity housing cooperatives offer a really good alternative to make sure that low and moderate income people have an opportunity to stay housed, but then also to own a little bit of something. And so what this bill does is it creates a clear and accessible pathway for existing tenants to become homeowners through a cooperative ownership structure, prioritizing long-term affordability and housing stability over market rate equity appreciation. And what does that all mean? Now, that'll come out in the mechanics in the bill and in the subsequent testimony. By establishing this process, I think it reflects the realities that, and you'll hear this from the tenants, that they face when you're trying to purchase that first condo or that first house or housing unit, and it allows for a more accessible option. So the mechanics of the bill, it establishes the conversion parameters for a Maryland non-stock corporation to become a cooperative limited equity housing corporation. I'm just going to call it an LEHC for short. It makes it easier for residents to convert their building into this LEHC, which is where each member or each unit has an ownership share of that cooperative when they convert it. So if the tenants get together, they want to buy their building, this is a mechanism for them to do it in an affordable manner. It creates clear guidelines for conversion, including you have to give 60 days of a notice for an intent to kind of file your intent to convert. It allows for voting rights. It spells out how the voting rights are going to be allocated or apportioned through the LEHC. Each resident, before the conversion happens, will be given prompt written notice. The resident will be given no shorter than 90 days before the conversion happens, before that application or that vote happens. So they'll be given ample notice for someone to have notice for before this application gets filed and before a vote takes place. If an eligible member of the co-op fails to accept the offer or is ineligible to accept the offer, they have to leave that unit after this conversion with some exceptions within 90 days. And the exceptions apply to 12 months for a disabled person or senior citizen who has been a member of the household for at least 12 months, or the household is a low-income household, or the LEHC notifies that they wish to remain in their unit for a period of more than 90 days. There's some leeway and flexibility. So when this conversion process happens, the people that are currently residing in this building have an opportunity to stay under these circumstances. So there's a little bit of leeway and elasticity there. A low-income household required to vacate shall receive, under this bill, some reimbursement for their moving costs of no less than $375, no more than $750. There are restrictions on the appreciation of the property, and that's to keep it affordable. So when that member chooses to sell or leave, then when it goes back onto the market, that unit still remains accessible. You'll hear from the Leland Tenant Association why that's so important. And then it prohibits local governments from developing disparate restrictions on this transfer so that you have a uniform system across the state. There are some forthcoming amendments that are technical that the county has offered and that some other attorneys have offered, but I would categorize them as technical in nature, and we can go over that when we look at this bill before we vote, but nothing, I think, extremely substantive, things like effective dates, and I think MML or MACO has an amendment to make sure that some of those restrictions, we're going to preempt their ability to change what this law does. Some of those, there's some technicalities that they want changed, and I think those are acceptable to me and to the cross-file across the street as well. So with that, I will ask for a favorable report for a bill that's going to provide, it's a creative solution to provide more stable housing in a state where the lack of affordable housing is costing us in terms of population, in terms of tax base, and it's pricing people out of housing markets. So this is a really creative, innovative solution that's gaining popularity across the country. And so with that, I'll ask for a favorable report, and I'll retire, let the panelists present, and then I'll stand by for questions.
I'm quite a bit shorter than Senator Smith, so I have to adjust the microphone. Thank you, Senator Smith. Good afternoon, Vice Chair Waldstreicher and members of the Judicial Proceedings Committee. My name is Sasha Olinik, and I am the president of the Leland Tenant Association, or LTA. The LTA is a group of neighbors committed to nurturing the sustainability of our larger community, keeping our homes safe and affordable, and supporting each other's well-being. In 2021, our landlord put our building at 112 Lee Avenue in Tacoma Park up for sale, which threatened to displace all of the 15 low-income households living there. In October of 2022, the Leland Tenant Association utilized Tacoma Park's tenant opportunity to purchase law to successfully acquire the property. The LTA's intention has always been to convert to a limited equity co-op, ensuring that it would remain affordable and owned by the residents in perpetuity. Although more than 90 limited equity co-ops thrive in the District of Columbia, there are none in the state of Maryland. We soon learned the reason why. The existing laws make the creation of a limited equity co-op confusing, costly, and time-consuming. SB 0511 would simplify the process and allow more tenant associations to follow our example. This bill, were it to become law, would create another tool to stem the growing housing crisis within the state of Maryland. I urge a favorable report on SB 0511. Thank you.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, Senator Love, who represents me in District 16, and members of the committee. I am Doug Ryan, Vice President of Housing Policy at Grounded Solutions Network. We are the nation's leading nonprofit on housing with lasting affordability, including community land trusts, inclusionary housing, and limited equity housing cooperatives. We are motivated by opening avenues to home ownership for those who have been left out. I'm a longtime housing advocate, including working at the HOC of Montgomery County for 13 years, and I am a 2-decade resident in District 16. Maryland is facing an existential housing crisis. It's gutting our economic future. According to DHCD, in the year 2000, close to 75% of households in Maryland could afford the median valued house. That number has dropped to below 50% 2 years ago. Hopeful renters in our state may simply just give up on the Maryland dream. We're here to help address that. LEHCs are one tool that Marylanders can hope to access homeownership and avoid economic uncertainty. Making it easier for residents to convert to LEHCs will reduce displacement and will position them to take ownership and manage their futures. I think that's critical. SB 511 will make this possible. Current law is designed for-profit market rate housing developers, not for resident-owned communities. SB 511 creates a clear, simple path for residents to pursue conversion while requiring transparency and maintenance reserves to ensure future success. Many cooperatives organizations simply do not have the resources to navigate existing processes. They shouldn't have to, as is evident in New York, Connecticut, Massachusetts, DC, and elsewhere. Maryland should be next. A limited equity housing cooperative is designed to be affordable to people with low and moderate incomes. Homeowners build equity while paying affordable monthly maintenance fees, and when a family moves out, they sell the home to an eligible family at an affordable price, creating true, lasting affordability and community assets. We urge your favorable report on SB 511. Thank you.
Good afternoon. My name is Claudia Wilson-Randall. I'm the Executive Director of the Community Development Network of Maryland. We're a statewide network of advocacy partners in community economic development in Maryland. Today, I want to speak in strong support of Senate Bill 511. The limited equity co-op statute in Maryland is just simply unworkable right now. And so what this bill does is make that statute workable so that tenants like the Leland Association and other parts of the state, other associations can actually form co-ops that work and that can be converted. So I just want to amplify a few points about this model. This is a different model from a condo association, and it is important for I think for Maryland to have this option for tenant associations. This is a really important way for us to create more affordable housing in the state of Maryland. Some of the benefits, residents have greater control and input in their decision making. And I think this is an important social aspect of this cooperative housing. It's an important tool for affordable home ownership. And what's distinction about this is you don't own your apartment, you own 1/100th of all of the apartments, right? So that's the difference here of the cooperative is important, that distinction. More stability and I think more opportunity for economic advancement of families and within the co-op, and building stronger communities with amenities. I think it's just really important that at this time we think about strategies that uplift people and not just uplift property. So I urge your strong support for Senate Bill 511. Thank you so much.
All right, Senator Love, Senator James, Senator McKay, and then Senator West.
Thank you, Mr. Chair. Mine is more a point of personal privilege. Mr. Ryan, thank you so much for being here. It's great to see you.
Thank you very much.
Senator James.
Oh, thank you. Two questions. One, the gentleman from Tacoma Park, thank you. You were able to convert your apartment building to this model because there were local Montgomery County laws that allowed you to do it. Is that correct?
No, we were able to acquire the building. The association was able to acquire the building. We have not yet been able to convert to a limited equity co-op. We tried, but it's incredibly difficult and almost impossible.
Okay, well then I'll follow up with you all about the fact that he was able to do this without us changing the law. And I just want to kind of understand what the benefits would be if you can do this under existing law. And I don't want to put this gentleman on the spot. Thank you very much. And then you can follow up, but I noted the model is different than a condo association, and we do have a wonderful delegate who's an expert in condominiums who's not, here with us today. But I do know just generally that they have a lot of formality to them, a lot of it, and as we saw in the tragedy in Florida, for just one example, when maintenance was not adequately kept up, lives were lost. So my issue or my questions are around how we are going to protect the residents' health, safety, and welfare, how we would hold people accountable. I mean, I love the idea of getting people this accessible housing option, but I also don't want to put anybody at risk inadvertently or otherwise. So I know it might be a meaty question to answer, but
just tack back to the first one. I mean,
yeah.
Washington D.C. has done this. I think they have 5. You said 5,
right?
More than 90. Sorry, more than.
Yeah,
90.
I heard that.
So I mean, and I don't know if but if you could speak to the Maryland Co-op Act and why it's laborious and litigious and very difficult to kind of, is unworkable for creating
it's
this
so
framework.
big. I don't want to make this too long.
Yeah, no,
I do
no.
want to understand how you protect
But then
the building and the
bill
residents.
does also require, I mean, there's limited equity that can be accrued, but there's also maintenance is incorporated in there. So that the maintenancing of the building in terms of all the safety and all the regulations from county, from city, for state, all still apply.
So reserves
But the
to-
money, exactly right, is
Okay.
all baked into this. Although there's a formula that caps how much equity can accrue when you sell it, the maintenancing is part of that fund.
So if I were to ask a legal expert in this area, or several,
And then you can
just in general in this, they would say to me, look, the way we're structuring this, without getting into the details right now, provides the same excellent protections that other systems pre-existing right now do in terms of protecting the building, the maintenance, the health, safety, and welfare, and holding someone accountable should there be a failure in that regard. The answer I would get from experts would be yes, and we can talk about how.
Sure. I mean,
And
thank
it's
you.
in the bill, or you're adopting laws, or are you making reference in the bill to other laws that you're incorporating by reference?
Well, the bill also would offer the DHCD to offer regulations and guidance. So I think that's critically important. So the other piece of it, to your earlier point, there are about 125,000 cooperatives, LEHCs across the country. In the states that I focus on, a lot of them are in New York, but also Connecticut, Massachusetts, and as we said, in DC and elsewhere. There have not been any failures like you're fearful of, which I understand your concern, that we are aware of.
Okay.
I will also add that the building up reserves for maintenance of the building is critically important.
Right.
And that's done as part of the development process, and the pro formas will represent those things. And that's critically important too. So I think that's important. But I think in contrast to condo opportunities and things like that, we have seen one reason, Montgomery County, for example, where I live, is not building condominiums. It's really prohibitively expensive in many ways. There's lots of reasons why they're not being built, but of course they become costly as they age because of fees.
Yeah.
This program, this model, can help safeguard residents against that. We wouldn't be advocating as a nonprofit that works nationally unless we thought this model worked. We have partners across the country that have done this effectively, and we think it can be done effectively in Maryland. And I will just close on one minor point about why we think the current law needs to be addressed. These don't exist in the state. That must speak something about what's working or not working in the state of Maryland.
So again, you can follow up with much more detail later, but
Sure,
you
thank
do
you.
assess some kind of dues, because, condominium and homeowners associations are sometimes shocked.
Oh,
when
sure.
and then they don't have the resources, or the assessment's going to be extraordinary. So you do have a mechanism here where people are paying all along to put money into the
Absolutely. They pay a
fund.
monthly maintenance fee, carrying charges, different states call them different things, but that's absolutely right.
All right, thank you, Mr. Chairman.
Thank you.
Senator McKay?
Mr. Chair. Mr. Chair says I can ask Mr. Chair a question. Anyhow, so are you familiar with land installment contracts?
I'm not.
Okay. I think this already exists.
This
This
LEHCs?
already in Maryland, land installment contracts. And I actually know of about 5 or 6 different examples if we are doing it. And I just, because you don't know about it, you won't know to tell me what the difference is and the benefit. And if there's anybody else that does know. So I'll talk to you offline.
Yeah, that'd be great.
This already exists, and I know of about 4 buildings that does this already.
Where where members can become basically shareholders of.
It is residential units, one residential unit that is then sold to the individual people in there, and then they all own their part of that building. But there again, I'll talk offline.
No, yeah, I mean,
because
I
I
think
don't know if it's apples to apples. That's why I'm saying I'm trying to understand the co-op part of it, because it sounds like it's putting an awful whole lot more burden on the owners than just using a simple land installment contract.
Is there an emphasis on affordability and maintaining that affordability, in terms of the capping on the equity and when you put the unit back onto the market?
Well, when you put it back on the market, those are individual units that are sold. And so, I mean, I understand some of the safeguards that you're talking about.
Yeah.
But at the end of the day, all those safeguards are administrative building of charges and how it all, anyhow, we'll talk offline.
Yeah, that sounds good, yeah. So you want to say something?
Sure, if you don't mind.
Yeah.
Thank you, Senator, for your question. A couple things. I am not familiar with land installment contracts, but with all due respect, I suspect I'm not, because they probably don't work for the demographic that we work with at Grounded Solutions Network, and frankly, I've worked with my entire career. A couple differences. One is that a lot for these properties to work as they have in different parts of the country in different states, and also in, for example, resident-owned communities, which preserve manufactured housing communities and turn them into resident ownership, which is also not happening in Maryland, which is also a flaw in state law. I would argue a couple things. One is that they often require some public subsidy or some public trigger, like Sasha mentioned the local law in Tacoma Park. That should mandate and require that the public, the taxpayer, gets in return, a return meaning lasting affordability beyond generations. I think that's critically important. From what I heard you say, and correct me if I'm wrong, but I'm going to dig into this when we finish up, the land installment contract probably doesn't protect future generations of low-income homeowners. I think that's critical for public policy. So I would start with that. Oh, I'm sorry, please.
No, sir, I'm just going to say, land installment contract doesn't involve any kind of public money whatsoever.
Understood.
So to protect the public in the future and all that kind of stuff, this is just the actual transaction to people who actually own their end of unit. Good, bad, or indifferent, it
Absolutely.
exists, so.
But and also a limited equity housing cooperative, as they are designed, would also have favorable tax treatment, which also is a public subsidy indirectly. So I think that's critically important as well.
Right, I guess maybe I didn't understand. If you don't get a public subsidy, then the public really doesn't need to be in any private. Really.
Understood,
So,
but
and these things have happened and do. And we're not asking the taxpayer to be part of it, to be funding something and that kind of stuff. So.
I understood. I don't think that's going to be in every case, but I would just also close with one thing, is that the democratic governance is critically important to this model as well. Sasha and Judy and their neighbors get to manage this property, how it moves forward, from the capital improvements to decoration to whatever else it may be, and this is going to differ across the state and different.
And I concur that may be the biggest difference there.
I appreciate that.
And then it gives a framework for how they're going to work together as units. But
great.
There again, we have rows of townhouses. Anyhow, we'll talk.
I appreciate that. I'm going to look into it. Thank you,
Senator.
Senator.
Taking up chair or chair's time.
You're fine. Senator West.
Could I talk to the sponsor of the bill? So when you tried to portray this as a way to help solve the state's lack of affordable housing, as I understand the bill, it provides for conversion of existing rental facilities. So we're not talking about creating any new rental facilities.
No, but it does make available affordable housing stock in perpetuity. And so that's an important component as markets, as housing increasingly gets expensive, and because we're behind in building housing stock, it's only going to continue until we can level that playing field. The availability of affordable housing stock for generations is extremely important, and this helps preserve that affordable housing stock.
Gotcha. But when I hear about our need for more housing, my takeaway is we need to construct more housing.
Yep,
and this,
that's true.
This bill won't construct more housing. It would just convert existing housing into a different form of ownership of the existing housing.
And making it accessible and affordable for moderate and low income folks.
Right. So I noticed that Mr. Carlson took a look at this bill last year from the corporate side, which I think I suggested.
You did, and he did so again, and that letter.
Right.
I wouldn't. I'd hazard to read all of that into the record just because it may have been a private communication, but
yeah. But it sounds like he's now. I place a lot of faith in his judgment because he's like the state's guru of corporate law.
As do I. Yeah.
And so he took a look at it from a corporate point of view, and he says it's okay. He does specifically note that he doesn't have the ability to weigh in on the real property issues involved. Including the rights of the pre-existing tenants. Has the bill been run by some representative of the state's real property section for their take on whether or not this would pass muster, or whether things should be done to this bill to make it segue properly with the state's existing real property statutes?
No, he's the only one from the MSBA, but we've had attorneys look at it from Klein Horing, Heath Covington, and obviously Grounded Solutions has been at the table creating this iteration of the bill. I'm happy to run that by the MSBA again. But yes, we've had a very diverse set of stakeholders look at this bill for 2 years.
I think someone with experience in more experience than I've had in real property law ought to take a look at it to see. And specifically with respect, as I understand what happens under this, you've got a building which is privately owned right now, and a group of tenants would like to own the building as a co-op, and so they're going to raise the money amongst themselves, or by borrowing it, to acquire the building from the current corporate owner and then turn it into a co-op.
Yeah.
And that would be a negotiated transaction. But the concern I have is telling the existing tenants who have leases that they're going to have to move out because they're not, and their leases will be abrogated in favor of a new tenant who will be a member of this co-op, and how that would comply with existing law. And I don't see an answer to that in the bill. I think it would be helpful to have someone from the real property section take a look at that.
We actually I talked about that with council a little bit last night and yesterday. So the bill does provide, and you feel free to chime in here, but the bill does provide, obviously there's a democratic process by which this happens, so there's going to be a vote, and we can talk about the formula, the structure of the vote, and what percent.
Sudden, even though I've got a 5-year lease, I'm going to have to vacate the apartment, and I'm wondering how that complies with Maryland law, or whether that is constitutional under Maryland law.
You can't abrogate those contracts. I mean, and then we've also talked about, look, I mean, you can, if you've seen these happen, but we were talking about, look, we're going to ponder, we're going to have a good cause bill that comes through here next, and we're going to talk about that. That good cause goes into law. I've sought guidance as to how that would interface with this as well.
And then the last question I have along the same lines is, we've passed a lot of bills during this is my 8th year in this committee, a lot of bills dealing with common ownership communities.
Yeah.
Many of them brought by a particular delegate who has some expertise in the area. I'm just thinking of one, because I've got my own bill dealing with it, which we'll hear shortly, dealing with these reserve funds. So in the other common ownership communities, co-ops, condos, homeowners associations, let's talk about the parking lot. If the parking lot will have to be repaved, say 20 years down the road, the members of the common ownership community have to put money in the reserve fund periodically, so that at the end of the 20 years, there will be enough money in the reserve fund to pay to repave the parking lot. I don't see similar language about reserve funds, just to select one of the things that we've legislated on in this bill. Do you think that we ought to provide that for this new form of common ownership community, that it is subject to the same requirements that we have imposed on all the other common ownership communities over the past 8 years?
No, I think that's a very good question, and that's something that I also talked to about council. I would not be adverse to that. I'd have to think of the kind of the secondary and tertiary consequences. I think that's good because we've obviously put these into place for safety and for longevity, and to Senator James' point. So, yeah, exactly. You just did. No, you did. You were. Well, all of the protection, in terms of the reserve fund, it is in there. But in terms of the other limitations we've placed on co-ops, I couldn't answer you today whether everything that we've placed on other co-ops would be applicable here. That's guidance that I'm going to seek, that I've had conversation with council. But in terms of the fund, that is pondered. Yeah.
Thanks for your answers.
Senator Folden.
Thank you, Mr. Chair. So that was kind of where I was going, because that's been a very impactful to the negative piece of legislation that was handed down. That's really
Which one?
With the homes and the assessments and how they, that piece of legislation in and of itself has really negatively impacted a lot of people in these co-ops and these elderly, especially the elderly on fixed income.
Are you talking about like the BEPS thing, or?
It's been.
That's one of them.
Yeah, we've been fighting this now, hopefully trying to clean it up. I'm hopeful. I don't know that we got it done last year even. But we can talk about that on the sidebar. So it kind of got me, so I thought he was going to go there, but So we have this doesn't offer any new affordable housing stock. This references affordable housing stock, but the thing that it doesn't address is when we look at those things that are, if we ever did expand this to talk about affordable housing stock, it doesn't talk anything about the taxes, the building assessment fees, and the impact fees. So, but this bill talks about, I think somebody said that it would restrict the appreciation.
Mm-hmm.
So how much is the appreciation? Like how is that restricted within like a controlled environment, say like Montgomery County, and where the SDAT is been very diligent in recent years of increasing everyone's, evaluations. So I'm curious how, because the valuation is then directly impacts
the tax
base, which impacts how much their payment is. So there's nothing in here, and correct me if I'm wrong, but is there anything in here that would restrict or make SDAT like a little to assist in this endeavor that we're trying to do to also restrict their assessments? Because I would like to say that it's just the, affordable housing that's being impacted by affordability in Maryland, but it's everything. Because now for another year, we're getting ready to get hit with another, I think the last number I heard was 12% increase in taxes by SDAT, our good friends at SDAT, making sure we have extra money that we get zero extra services for. So I would be curious as to that. Is there anything in here that would restrict SDAT's ability to continue to increase at the rate that they're doing in property valuations?
That's a terrific question. I really appreciate that. And actually, that speaks to some of the work that we're doing in Maryland on other issues. So as I mentioned in my testimony, we will also work with community land trusts. And what we're seeing in Baltimore City is that, which we have a number of members, partners, nonprofit CLTs, we are working with SDAT to ensure that SDAT, when they do the assessments on those units, those which are homeowners, but they don't own the land, so that's the difference. So the value shouldn't appreciate. But they have, in a CLT, they have a ground lease. In a cooperative, they will have a restrictive covenant. So that limits the appreciation in the individual unit that the homeowner can sell in the future. Okay. So SDAT has to use that as part of as one of their metrics when assessing the property, in the 3-year cycle. So that's typically how it works. Now, have there been some bumps in the road? Sure. But we are working with SDAT to ensure that they recognize that their staff are trained on that, and we're doing that in Baltimore City, and we'd be happy to work with the LTA, Sasha and Judy and their neighbors to make sure that that happens, and I'm confident that Montgomery County would be working with us as well on that, because that is driven by the locality, working with SDAT, as you know.
Okay. Thank you for that. And then, that's wonderful. Thank you for your answer. And then what happens is there a way for the ownership then community to say, you know what, this isn't working for us? Is there an exit strategy to convert it back to? I mean, is that?
They would be able to take a vote, I assume, and dissolve, just like any other, not a corporation.
And that vote would be like by a percentage, because that was like my final question was.
That's a policy call.
Yeah.
So, yeah.
So there is an opportunity for them to exit out if they wanted to. Like I'm talking about out of the co-op altogether.
Yeah. Yeah.
And if they disagree, it's put to a vote on, like when they were talking about the amount of funds for replacing the parking lot or whatever that is. Like that's all to a vote. And then whatever the policy is wins. Is that right?
I think that's right. And the legislation that you're considering has, I believe it's a majority vote. I will also just add that in our experience across the country, you don't try to convert when you just have 50+1. You want to have as many people on board as absolutely possible. That's critically important.
The way it's drafted now is 50% of the people present.
Right.
It's an amendment that I have to make it 2/3
of the owners.
Yeah.
The ownership, because that's what we're talking about here, right?
Yes.
They're creating ownership. So it shouldn't be of members present. It should be of owners.
I agree with you.
So that is a very important element too. So thank you for that. Thank you.
I had a question for Ms. Wilson Randall. In your testimony, you had pointed out that there was something. You said it was important that when talking about ownership, it wasn't necessarily ownership of an apartment, but it was ownership of a specific, I guess, apartment, but ownership or percentage of.
Yeah, no, the distinction I'm making is you don't own your unit, you own a share, right? And so there's just a very different place, like to be clear about what the distinction is about the cooperative agreement where you own your apartment, right? And that's that also speaks to the issue that you were talking about, which is around the land installment contract, where you own your apartment, right? And this, you own a share, right? And that share gives you the right to have an apartment in that place, right? So it seems like a small thing, but I think it's a really important distinction about the co-op model specifically, because you don't own your apartment in that same way. And so that's the distinction I was making.
And I've been listening, and there have been some questions about ways of addressing the affordable housing problem in the state. And I think I've been hearing from my colleagues, the thought is you have to build new, but in the industry, it's not only is building, but it's preservation as well, correct?
Correct. So I want to say also the Tacoma Park example is a really important thing, that 15 people live in a building, right, today, and at the time that they wanted to convert. Had they not had that ability, then someone would, sell that building to a developer, and it becomes a luxury home with maybe only 2 houses on that property, right? So that loss of what we think about is naturally occurring affordable housing in the Maryland market would be significant, right, in that example. The other, so that's not only preservation, right? The other thing that could happen to that building is it could be completely sold and made into luxury apartments, right? So then we've lost that. So there are a lot of forces at work on this affordable housing problem. We not only have to add, we also have to preserve the affordable housing that we have, that we currently have in the state of Maryland. And so we have to do both at the same time. And I think our sponsor talked about it quite eloquently at the beginning. There's a lot of forces here at work, but we not only have to preserve the housing that we have, but we also have to figure out how to add. And so it's not one or the other, it's both. And it's all happening at the same time. So that's a really important distinction.
Which is one of the issues when you're dealing with your low-income housing tax credit projects that have aged out beyond tax credits.
Yes, expiring loss. And I would even say in the single-family market, we have currently a lot of elderly residents throughout the state of Maryland who are living in houses. They are fully paid off, but they need maintenance. And in order for them, how do we help them retain the affordable housing that they have today? It's a critical issue for the state of Maryland.
Thank you very much. And Senator James.
Follow up, but it just begs a couple of questions just popped in my head. The valuation of this and inheritance. So you were talking about keeping this affordable in perpetuity, but you've had 15 families and they all, or even 10, just 10, and everybody ultimately dies, right? And
so, Senator, yeah. I'm going to follow up with you in more detail for sure.
That's fine.
But what's critical about this co-op issue, this limited equity co-op, is it is not a market-driven thing. It is so that the critical part for me is that people are preserving affordability. Their valuation is capped at the rate of inflation, so only 8% a year for that individual who has that share. And what they are, the valuation of the building is a whole separate market-based piece. They're not selling it to leave it behind in the same way somebody would own.
Well, that's what I'm just saying. I'd like to understand what happens when people die and they still have their 1/10 of 100% or whatever their share is, and how that's valued, and then how it is inherited or not inherited, what the differences are. You can certainly follow up. Thank you.
I'll be sure to follow up. Yes. Thank you.
All right. Thank you all. Is Mr. Scott Bruton, is he? All right, come on up.
Go to the podium, go to the chair.
Oh, to the podium. And Kimberly Poole? Kimberly Poole is not here. All right, the floor is yours.
Thank you very much, Chair Smith and members of the committee. My name is Scott Bruton. I am the Director of the Department of Housing and Community Affairs in Montgomery County, Maryland. I am here to speak strongly in favor of the passage of this bill. I will say that DHCA in Montgomery County, Maryland, we funded the acquisition and the rehabilitation of this property, so we are very interested in it fulfilling its road to becoming a limited equity housing cooperative. I'll also give you a little bit about my background in case you want to ask me any questions. Prior to joining Montgomery County in 2023, I worked for over a dozen years in the District of Columbia, working for nonprofit organizations on everything from homelessness prevention to affordable housing. I helped with negotiate the creation of several limited equity housing cooperatives through the, like the entire phase of development and rehabilitation. I also was commissioned by the District of Columbia government to write a study on the 50-plus history of the creation and long-term viability of limited equity housing cooperatives in the District of Columbia. And as people who have spoken previously noted, there are actually over 100 limited equity housing cooperatives in the District of Columbia, and some of them have been in existence for over 50 years. And so with that said, they are a very useful tool for preserving affordable home ownership for the long duration for low and moderate income homeowners. And I am happy to answer any questions you have, even some that were, like if I could add to any of those that were asked earlier about how limited equity housing cooperatives work, their viability over the long term, and how they are treated, at least in Montgomery County, the same as, would be treated the same as any other common ownership community.
Thank you. Seeing no questions. Ms. Poole, I'll call the name one last. Is Ms. Poole here? All right. Seeing not, that will end the hearing on Senate Bill 511. Thank you very much. Senate Bill 471. Oh, that's what. While the chair is busy, if one of you would like to.
Thank you, Chair Smith, Chair Wallstreicher, and members of the committee for this opportunity to testify in support of Senate Bill 471. For the record, my name is Dawn Lindsay, Clerk of the Circuit Court for Allegheny County. I'm also representing the 24 elected clerks of the Circuit Court in Maryland. We support Senate Bill 471 because the advantages of streamlining the process for setting the salary cap for the clerks. I have been involved in salary legislation for the clerks since 2002, and for all of those 20-plus years, we have received requests from legislators to find a better way to set the cap. We think tying the clerk's salary to that of the state employee schedule would accomplish that objective. As is currently the case, the legislature sets the maximum cap for the clerk's salary, but then the actual salary for each clerk is set by the Board of Public Works. Under this proposed bill, the Board of Public Works is still responsible for setting the clerk's salary, but since the cap is tied to the standard salary schedule for Maryland state employees, the legislature would not need to separately set the cap for the clerks every 4 years. The state employee salary schedule is already subject to analysis and evaluation to ensure that it stays in line with the cost of living and general market conditions. This way, the salary cap would stay in line with state employee salaries and not become too excessive or too deficient. The legislature has already adopted the option of tying salaries to an existing standard for several other offices whose salary is set in statute. This includes nearly all the state's attorneys and sheriffs in the state of Maryland. This option has worked well for the other offices, and there's no reason to believe it would not work equally well if applied to the clerks. And if at some point in the future the legislature decided for any reason that tying the salary cap to the state employee schedule was not working, the legislature could undo it and set a new standard. I ask for a favorable report on Senate Bill 471 and would like to thank Senator Smith and McKay for sponsoring the bill. Thank you for the opportunity to comment, and I'm available if you have any questions.
All right, thank you. Whoever would like to go next?
Good afternoon. Thank you, Chair Smith and the members of the committee for this opportunity to testify in support of Senate Bill 471. For the record, my name is Mahassan El-Amin, the Clerk of Circuit Court for Prince George's County. The Circuit Court clerks are the administrative arm of the court, but we are truly the heartbeat of the courthouse. We are often the first point of contact for the public. People cannot speak directly to judges and usually must engage an attorney before obtaining legal advice, which often comes at a cost many cannot afford. While we cannot give legal advice, we can direct people to resources, and most importantly, we listen to their concerns and treat them with kindness and compassion as they navigate a complicated and often intimidating process. Collectively, the clerks oversee more than 1,500 employees statewide and handle about 200,000 new case filings every year. The job we do, largely behind the scenes, impacts people's lives. Among our many responsibilities, we make sure that millions of pages of documents related to these cases are processed in a timely and efficient manner. When a matter is before a judge, the clerks are the ones to make sure that the case is in the right place at the right time. When a judge sentences a defendant to incarceration, we ensure that the sentence is properly recorded so there's no mistakes, releasing someone too soon or keeping them longer than they should. We also ensure that guardians are assigned to care for vulnerable individuals and process audits to make sure property is not stolen. Beyond the courtroom, we serve as the recorder of deeds, maintaining land records that drive Maryland's economy. We record transactions worth billions and collect over $400 million in land record revenues annually. And without us, the real estate market stalls. The role of the carries a cherished legacy. In the spirit of Black History Month, I'm proud to note that Frederick Douglass served as a recorder of deeds in Washington, D.C. We have big shoes to fill. We also preserve history. People come and look at us for marriage records and land titles, and we timely process expungements that give individuals a second chance. And in addition, we act as justice of the peace, ensuring more than 40,000 marriage licenses annually and performing approximately 16,000 ceremonies each year. So we ask for a favorable support for this bill, and thank you very much.
Thank you.
Good afternoon. Thank you, Chair Smith, Vice Chair Waldstreicher, and members of the committee for this opportunity to testify in support of Senate Bill 471. For the record, my name is Kevin Tucker. I am the elected clerk of court for Washington County and a past president of the Maryland Circuit Court Clerks Association. I support Senate Bill 471 because of the small fiscal impact of the requested salary cap. Since the legislature sets the maximum cap on the clerk's salary and the Board of Public Works actually sets the salary for each clerk, there is no fiscal impact if the Board of Public Works does not increase our salaries. However, if the Board of Public Works does increase our salary, established by Senate Bill 471, it will still have a very small impact on the overall budget of the judiciary. Even the maximum increase would only equate to about $500,000 out of the judiciary's approximate $800 million annual budget. The judiciary, which supports a salary increase for the circuit court clerks, has already included this funding into their budget request. It should also be noted that as elected officials, Article 3, Section 35 of the Maryland Constitution only allows for our salaries to be adjusted once every 4 years. So while other state employees, including our staff members, have received cost of living and merit increases over the past 4 years, we as clerks have not. Senate Bill 471 ties the clerk's salary cap to grade 26, step 20 of the Maryland State Employee Salary Schedule, which would give the clerks of court only the same increase that all other judicial employees have received over the past 4 years. It would not vault our salaries over those of other employees, but it would bring us into alignment with the salary adjustments other state employees have enjoyed over the past 4 years. In addition, grade 26, step 20 is consistent with the salary level of comparable senior leaders in similar positions within the judiciary. It is also consistent with the salary of the clerks of both the Supreme Court of Maryland and the Appellate Court of Maryland. Together, the clerks of court manage about 1,500 employees, which is about a third of the total personnel in the judiciary. We manage over $160 million in budgetary expenditures each year and are considered senior leadership positions within the judiciary. I ask for your favorable report on Senate Bill 471 and would like to thank Senator Smith and Senator McKay for sponsoring this bill. Thank you for this opportunity to comment, and I am available should you have any questions.
Thank you very much. And my Register of Wills.
Thanks very much. I want to thank Senator McKay and Senator Smith for sponsoring this legislation, and it's great to see you, Senator Sidnor. My name is Alexis Burrell-Rohde, and I'm the Register of Wills for Baltimore County. I'm also the current serving president of the Register of Wills Association, and I'm here speaking on behalf of the Register of Wills regarding Senate Bill 471. The Register of Wills is a state-elected constitutional office, and we're charged with devoting our full working hours to our work serving the public. And we have a really unique role in the state of Maryland in that we work with families who've experienced the death of a loved one. So it's a really sensitive job, and it requires a really light touch. And the vast majority of our families that we work with are unrepresented by legal counsel. So we translate the complex, sometimes complex probate process into terms that families, unrepresented individuals are able to understand and access. Sorry, I'm a little distracted. So in addition to helping families navigate probate, we hold wills for safekeeping. So right now we have 650,000 wills for safekeeping. We've issued 2,300 certificates of domestic partnership, and we allow the public to access over 1 million records. So people doing genealogical research, beneficiaries who are concerned about the administration of their estates and have questions. We also work with beneficiaries, and our job is to ensure their rights are protected. So while the registers are included in the 471 along with the clerks, we are funded a little bit differently in that our offices are self-funded. So for the last fiscal year, we collected $120 million in fees and taxes, and we were able to remit $90 million to the state of Maryland for use of the general fund, where our tax and fee collections are projected to be around $26 million more than they were in the last fiscal year. So that means that to fund the cost of living, or to fund the authorization of this cost of living adjustment, it wouldn't require any dipping into the state general fund in order to authorize that cost of living adjustment. And like the clerks have said, this is merely an authorization to set a salary cap that's linked to the general pay schedule of all other state employees. The Board of Public Works still has the ultimate say of whether or not to approve that. So there is some additional checks in that authorization process. So that's, if anyone has any questions, I'm available, but I really thank you for your time.
Thank you very much. Senator West.
So I do have a question. Ms. Rhode, I could ask you. I assume that in Baltimore County, the Register of Wills is pretty busy because Baltimore County has a large population and a lot of people die. But
Yes.
how about, say, in Kent County? So would the Register of Wills in Kent County be paid the same salary as the Register of Wills in Baltimore County?
No, the salaries are graded based on the size of the county. So a smaller county receives less of their salary is lower than in Baltimore County. So there's large, medium, small. I think there's a small, medium, and it all the salary varies on the size of the
Okay,
county.
and I guess the Board of Public Works would make the determination as to how much the register in Baltimore County makes as opposed to the register in Kent County.
Correct.
Got you. Thank you.
All right, seeing no more questions, assuming that the chair doesn't have to testify, or does he? All right, then that would end the bill hearing on Senate Bill 471. Next, we'll have Senate Bill 462. Senator Muse. Senator Muse.
Already had it in my hand. I was giving it a pep talk. Yeah, he said, you can do this. My man, that's right. Especially since Bob Enton, who hates this bill, he hates this bill, but he promised me a job at the bank. So I'm withdrawing now. Which one is first? Okay.
Too busy.
Right. All right. Chair Smith, Vice Chair, Chair Wallstrike, and members of this committee, I'm here in support of Senate Bill 462. As I said, Bob's best bill. Landlord and tenant residential leases and holdover tenancies. Local good cause termination, good cause eviction as well is what it's called, which authorizes counties by local law of ordinance to adopt good cause requirements for the non-renewal of residential leases and terminations of holdover. Dr. Kathy Howell is here to as part of my panel, and Matthew Hill, managing attorney at the Public Justice Center, and I'm sorry, Dr. Howell, associate professor at University of Maryland, and executive director of the National Center for Smart Growth. This is local enabling legislation. Let me repeat, this is not a requirement, it's not a mandate, it is rather local enabling legislation, not a statewide mandate. At its core of SB 462 is about housing stability and affordability. Stability matters. For children to be able to stay in the same school, seniors remaining near their doctors, and workers continue to live near their jobs. On affordability, we often talk about building more houses, but also need to talk about keeping people housed. Nothing is more costly than an eviction. The moving expenses, first month's rent, and security deposit. Plus, in this market, where are families supposed to go? Paying rent, paying families in their homes is crucial. Keeping rent-paying families in their homes is crucial to affordable housing. SB 42 allows a county, if it chooses, to require landlords to provide a legitimate reason before refusing to renew a lease or termination of holdover tenancy. Counties are not required to act. This bill ensures they have the authority to do so if they determine it is right for their communities. This bill applies only to corporate landlords who own 6 or more residential rental units. Small landlords are exempt. Owner-occupied rental properties are excluded. So this bill establishes a fair, finite list of good cause reasons, including serious leave violations or property damage, non-payment or habitual late payments of rent, illegal activity, refusal of lawful access, landlord or family occupancy, substantial renovations, or removal of the unit from the rental market. Counties may not add additional grounds beyond those that are listed in this statute. Evictions without cause create instability, not just for tenants, but for entire neighborhoods. When tenants fear eviction for reporting hazardous conditions, property fall into disrepair, lowering property values for everyone. So SB 462 promotes fairness, clarity, and predictability for tenants and landlords alike. Good cause eviction is widely supported by Maryland residents, with 73% expressing support in a recent Greater Washington poll. The research is clear that good cause eviction does not harm new housing development. My panelists will speak to this. 41 county officials have asked for this tool, including legislators in Prince George's County, yet Maryland remains one of only 5 states that prohibit counties from implementing good cause protections. Let me say it again. We are one of 5 states who do not have this provision. 8 states, including Colorado and New York, and 23 counties and cities nationwide have already passed similar laws. So why are we blocking local governments from making their own housing decision? This bill costs the state nothing, yet it protects thousands of Maryland families from unfair evictions. If other states and counties across the country can do this, Maryland should not be left behind. The issues is personal to me. It's I was homeless for a long time. I also know what it feels like to lose your home and know where to go. No one should be put out of their homes without being given a legitimate reason. And so for those reasons, I respectfully urge a favorable report on Senate Bill 462, and thank you for listening and for your patience. Okay. Oh, yes. And there are those who came down just to show support. I would ask you to please stand. Thank you all so much for coming down, participating in the process, and being a part of this.
Thank you, Senator.
You're welcome.
Good afternoon. My name is Catherine Howell. I'm an associate professor of urban planning at the University of Maryland, and I direct the National Center for Smart Growth at the University of Maryland, where we conduct practice-relevant and partner-driven research on issues related to housing, transportation, small business, and land use. Good cause is a critical tool for the prevention of displacement and the important acknowledgement that renters have a critical stake in our communities. Research from the University of Minnesota has researchers conducted the first analysis of the impact of good cause eviction protections on development. The analysis finds no evidence that the introduction of good cause protections in California, Oregon, and New Hampshire resulted in a decline in new construction. Additionally, pre-existing research has found good cause protections lead to a statistically significant decrease in evictions and a decrease in displacement. While I know this moment has been challenging for developers trying to build, we cannot use tenants and their instability as scapegoats for trends that are driven by widespread rising costs of development and the operation of housing, including land, labor, materials, and insurance, not to mention an oncoming recession. At the same time, economists have recently found that rent stabilization can reduce rent prices by 4 to 6% and does not reduce the supply of housing. In other words, rational rent stabilization along with good cause can create predictability for renter households, something I know I am happy about in my own life and I'm sure you all appreciate in your own housing. By knowing that if they follow the rules, tenants can stay in their homes, parents can engage more comfortably in their children's schools and their neighborhoods, and more importantly, they can relax and plan for the future. And it's, I think, worth noting that those who live in subsidized affordable housing already get these protections. This is part of the low-income housing tax credit requirement. And so this would actually extend it to a significant number of renters. And this is really important, right, in our communities in the backyard at University of Maryland, where rents are rising at a disproportionate rate. Largely, right, so we're seeing the push out from DC. We're also seeing the growth in the purple line, and rents are rising well ahead of that. So passing this legislation is important for the well-being of communities, and I encourage your support. Thank you, and I'm happy to answer any questions.
Thank you, Mr. Chair, Mr. Vice, and members of the committee. My name is Matt Hill. I'm an attorney at the Public Justice Center, which is a part of Renters United Maryland, and strongly urges a favorable report on the bill. It is critical to ground these discussions in the lives of the people most directly impacted by the lack of affordable, stable housing, including Rebecca Clausen, a 30-year combat veteran of the armed services, a mother to 3 teenage daughters, and a longtime resident of Anne Arundel County. Rebecca reported severe mold, flooding, chipping paint, and rodents to her landlord and then to the county. Her landlord responded by issuing her a notice to terminate her tenancy. Ms. Clausen retained one of the best landlord-tenant attorneys in the state, but lost at trial and lost on appeal. As she noted in her testimony from last year that is attached to my testimony this year, I have served my country honorably for 30 years, including combat service. Yet the very laws and freedoms in Maryland that I stood up to defend have failed my family. My children and I have been forced to endure hazardous living conditions, retaliation, and now eviction because the laws allowed landlords to hide. Now, because of this eviction record, landlords are declining our applications to rent another home. As a result, we will become one of the thousands of homeless families in Maryland. So I called Rebecca to see if she could come testify again or be here today. I can't get a hold of her. I've tried many times over the last year. The last I heard, she was living out of her truck in a park in Anne Arundel County. And what happened to Rebecca is not unique. When corporate landlords are allowed to hide their reason for terminating a tenancy, retaliation and discrimination flourish. If a family is paying the rent and abiding by the rules, they should not be evicted, period. It's also important to note the chilling effect of the current laws, which really disincentivize renters from complaining to their landlord or organizing because of this concern that they'll end up like Rebecca. Finally, we urge you to reject any amendment that forces counties to choose between good cause and strong rent stabilization or imposes restrictions on what rent stabilization looks like in other counties. You'll see in the testimony that there is testimony from Councilmember Mink in Montgomery County attaching the letter from 48 legislators from last year urging this committee not to force that choice. Thank you.
Excellent. Thank you very much, Senator, and thank you to the panelists. We have a question from Senator Henson.
Thank you, Mr. Chairman. My question is for Dr. Howell. Good afternoon.
Good afternoon.
Thank you for being here. There's been a lot of conversation surrounding the bill on the vacancy control that some of the local jurisdictions have enacted. Can you explain for the committee what vacancy control is and how that would work with the bill or how that impacts the bill if those two things were to coexist at the same time?
Sure. I mean, I think I would state first that it's strange to me that they're linked at all. These are two sort of very separate issues. What vacancy control does is that it says, look, if one tenant moves out, you need to keep the rents stable for the next tenant, right? And so if you decontrol that, that means that you're basically having one tenant lose their stability and the next tenant lose their affordability, right? And so, so I think that's really problematic with this bill, right? So that sort of cuts into the strength of the rent stabilization protections, I apologize, and makes it sort of that you really still can't predict your tenancy. You can't predict your affordability, right? Rent stabilization at its core is about predictability. And if we can't predict how the rents are going to rise, right, with, you know, whether it's CPI +2, CPI +3, depending on what the jurisdiction requires, then it's really hard for tenants to plan, and it's really hard to keep tenants in community. And I think one of the important pieces about that is that it's not like you can move and find housing affordable nearby, right? If you lose your affordable housing, and we keep shrinking our pot, right? No matter how much we're producing, no matter how much DHCD gets out there and puts their money on the street, we've got a hole in the bottom of our bucket that we're pouring water into, right? And this is part of that larger picture of affordable housing. Does that answer your question?
So you're saying that vacancy control is a feature of rent stabilization?
It is. It's an important feature of rent stabilization, right? Because
And-
otherwise your rent is not stabilized. You're much better at doing this than I am.
No, that's okay. So when one tenant moves out in vacancy control, the rent is held at what it was for the previous tenant for the next tenant? Is that
Correct,
what it
depending on
does?
how the jurisdiction kind of works, that there may be sort of, if you do renovations, there may be ways to increase in that way. You can apply to do those kinds of things. But essentially, it does try to keep it at the same rent.
Okay. And so if you layer on top of that a good cause eviction, you have to go through the factors, the qualifiers, if you want to not extend a renewal for the
Correct.
lease. If those two things exist in the same regime, how would they affect or impact each other?
I might actually look to my colleague here on this one, because I know you've been working on this a little bit longer than I have, but would that be?
Sure.
Yeah.
So from our perspective, they are two separate, completely separate provisions that the locality can choose to enact or not enact. There's also partial vacancy decontrol. There are vacancy bonuses. These policies vary around the country. Good cause, again, is about the landlord providing transparency around why a lease is not going to be renewed or a tenancy is going to be terminated. It's a transparency measure to provide, again, some protection against retaliation, some provision for stability, whereas rent stabilization is about keeping the rent predictable from year to year, regardless of whether or not the property goes into vacancy, which then keeps rents affordable for the entire community, right, with the vacancy control. If you lose the vacancy control, it loses that affordability throughout the community. So we see these as separate provisions entirely, and so it's definitely frustrating to have that conversation because we are trying to address two separate issues, in my opinion.
I appreciate that. We also, I think you heard in the prior bills, our concern as well is not just for the existing units, but the desire for new units, because we know that we're behind on the production of housing in Maryland, be it affordable, be it market rate, we just need more housing. So how would this policy impact the production of new housing in Maryland, if we know?
Well, I mean, so research elsewhere has said that it doesn't.
Okay.
And I think that's really important to point out. And I think that, again, we are looking for things we can change to improve the situation. But we are in a situation that it's really hard to build. I would say our neighbors to the south in DC, right? No one's going to accuse them of being weak on tenant protections. And yet, before this recent downturn, they were outperforming the more than three of our largest jurisdictions in the region in terms of housing production. Like the combined amount of those three jurisdictions was still less housing than what the district was creating. And so the idea that tenant protections are kind of the thing that's going to tank our housing production is really sort of highly unlikely, and the research does not bear it out.
Thank you. Thanks, Mr. Chair.
Thanks, no. I do want to, so just for the nexus between the two, I wanted to, and I'm not saying one way or the other, but here in my mind, to Senator Henson's question, I think, vacancy control and good cause are obviously very distinct and separate areas of the law. I mean, that's obvious. But where they are united is in their policy objective. Because for vacancy control, the reason why you would put that in is because you wouldn't want to put you wouldn't provide a perverse incentive for a landlord to put the unit back onto the market because they're not going to be stuck at the rent control amount right now. They can put it back on at market rate. That's a perverse incentive that you want to curtail. I understand that. So too is good cause, because you want to make sure that you have to have a legitimate reason to not renew the lease. You don't want to create perverse incentives because someone has complained or they decided they want to organize or whatever. So you want to protect that tenant from those perverse incentives. So while they are distinct areas of the law, they are very much united in their policy objective. And that's why they're often linked when you talk about it, in my mind at least, Senator Henson. Senator West, and then we'll come back to Mr. Hill.
Thank you, Mr. Chair. So vacancy control, you're telling us, is a little different than rent control, correct? Rent control says that you can't raise rents on a particular apartment until there's a change of ownership. And then vacancy control says you can't raise the rents even when there is a change of occupancy. Am I correct in distinguishing rent control from vacancy control?
They are part of the same, typically part of the same law. That's how you sort of keep the rent on the unit affordable. So if you think about the unit as the apartment or similar, right, then we're keeping the rents on the unit affordable, whether it's vacant or whether someone's living in it, or not affordable, stable.
So since you're standing there, let me address my other question to you. This committee, I think a year ago, heard testimony from somebody who I regarded as knowledgeable. I think the committee accepted him as knowledgeable. And he said, you can't build rental housing. No landlord has the money to build the rental housing with cash. They have to borrow the money from an institutional investor. And he said that there's lots of institutional investment money available to build rental housing in Northern Virginia. There's no institutional money available to build rental housing in Montgomery County outside of the independent municipalities of Rockville and Gaithersburg. And he said the reason was that Montgomery County is saddled with such anti-landlord restrictions that the institutional community around the country will not lend money to build rental housing in Montgomery County. So are you trying to tell us that if we pass this bill, which would be applicable if Montgomery County were to adopt it, that we would find, following the enactment of this bill, that rental housing would be constructed in Montgomery County? And if that's your testimony, please explain.
Yeah, and I would note that there are so many reasons why it's hard to build in Montgomery County and across the state of Maryland that the comptroller's report that just came out this year really did a great job of detailing, right? And this is kind of part of why the early vesting discussion is coming out in terms of the legislation, right? We are a late vesting state. So that means that if you're a builder and you do everything right, and you bring in your permits and you come in and the county decides to change the rules at the last minute, you still have to abide by those rules, which changes your pro forma. Now, I'm not sure I would invest in that. I don't know about you. So I think there are so many other reasons why we're having a struggle of building housing, period, across the state of Maryland, and our tenant protections are not the thing. And that's not what the research bears out, truthfully. I think it's a thing that we can control. We feel like we can say, I can change this. But really, we're also in the space. Maryland is a little bit different. We have the knowledge industries, and so there is a recession coming for us because NIH that saw massive layoffs, NOAA, NASA, all of these places are located in Maryland, and a lot of our support staff for our federal agencies are located in Maryland. Virginia doesn't have that kind of decrease. It's not getting hit as hard as we are in the state of Maryland. And so this is really important, that context. And so that's the piece of it, that we have the same tenant laws, in fact, actually more stringent tenant laws in the district, and they were doing a heck of a lot of building, right? They beat the mayor's goals for the production of housing. So I think that doesn't bear out both in the anecdotal work that we see in our very region and also across the country in national research.
Thank you.
Thank you, Mr. Chair. Mr. Hill, please, sir.
Matt, sorry, you wanted to finish up on that too. Make sure you got enough.
Yes, thank you, Mr. Chair. Would you like me to go to?
Why don't you do that first, sir?
Okay, thank you. So I was just responding to your point, Mr. Chair, which I agree with you in part, that there's a policy overlap partially between these two, the whole vacancy control and good cause eviction, in that you don't want to create a perverse incentive for the landlord to non-renew the lease so that they can then jack up the rent. Yes. There are other reasons for vacancy control that I understand the research bears out, and maybe Dr. Howe could speak to this. Vacancy control as part of rent stabilization keeps the rent affordable not just for the one person, but for the entire community, because then the landlord, upon that vacancy, can't just jack the rent up. And what the research says is if you look at jurisdictions that have vacancy control and don't have vacancy control, ultimately in the decontrol neighborhoods, the rents are pretty much market rent after a while. In other words, it doesn't work. Rent stabilization doesn't work for the entire community unless you have vacancy control. And then secondly, even without vacancy control, the landlord's going to have an incentive to find good cause. okay? Because if I know that I can jack up the rent if I get this tenant out, and if the good cause protections are not strong enough, I am going to find good cause that probably I would have let slide before, but now I'm going to actively look for a reason to evict this person so that I can jack up the rents. And so this is what the research says, and that's why we think these policies are important.
No, yeah, but at least in good cause, like, I mean, it's the burden, there's a burden shift, and then the burden in this bill at least is preponderance, but there is a burden shift on the other side. But
yes.
In all fairness. Yes. Senator McCabe.
Thank you, Mr. Chair. So, Mr. Hill, you, in your testimony, you had talked about, my words, this is directed to corporate landlords.
Yes.
Can you point me to that it actually is saying that in the bill, that this is just for corporate landlords, and what is the definition of a corporate landlord?
So, Senator, that's essentially shorthand for small landlords versus large landlords. We don't find too many large landlords who are individual people.
Understand.
Right? They're usually corporations of some sort. And so it's not directed. So anyway, so this bill only applies to landlords who own 6 or more units. And so corporate landlord is shorthand to express that. Generally, those individuals are going to be corporations.
All right. Is that 6 units for that particular building, or is 6 units in their corporation? Like I have 6 buildings of multi.
If you own 6 units, I believe it's by the unit. I'll have to double check.
All right. Do you know what the percentage of units that are large homes that would be 6 units or more that are not corporate entities?
I don't know that answer offhand, Senator.
Yeah, I just anecdotally.
Dr. Howell does, perhaps.
I don't actually know the answer, and part of the reason why is that ownership is obscured, right? So everyone will have an individual LLC for every single building, and so we've been actually trying to collapse that information, but it's actually a lot more difficult than maybe it should be because we don't know who actually owns the building because every building is an LLC, so it's very difficult to know that. When we do, we find large holdings, particularly concentrated in particular types of owners, and we know that large holding landlords tend to evict more frequently and be caught up for conditions more often.
There's language to circumvent that in this bill. To prevent that.
Oh, that's great news.
Yes.
Okay. Well, anecdotally, if you go to Washington Street in the city of Cumberland and you look at the approximately from the 200 block to approximately the 600 block, you'll find approximately 18 different homes that have more than 6 units that are all individually owned by people who have invested, especially when they invested in the 70s and the 80s when nobody would buy any of these things because you couldn't heat them, and they turned them into apartments. So an arbitrary number of 6 is not automatically a corporate. So maybe that's something we can look at. I know that my mother-in-law has 3 of these said apartments, and she's more than 6 in each of those. She's not a corporate person. She just wants to rent to people. She actually is below market, and it just seems to me what you're trying to do is actually going to end up hurting the people who small landlords are trying to help. Because at the end of the day, the smaller landlord, they just want to rent their property. And I don't know, and I'll ask the proponents, where in other contract law there is that says at the end of a contract that you have signed at the beginning of a 3-year, 1-year, whatever it may be, that you have the ability that now I have to tell you why you're not. And I'm not exactly sure why that matters, because if you fall into those things that are actually approved, what's the difference? It's a contract. You still have to move on. And if you don't want to live there, don't sign the contract. How would you answer that?
That goes in so many different directions, Senator, but very.
That's why this whole issue really frustrates me, because I tend to believe somebody who is a proud person, who's a second chance guy. I fill up my building with people who have, let's just say, have had places that they learned that they had to pay back to society. And I tend to believe what you're going to do is take people like myself who are willing to try to help people and say, why would I ever want to rent to anybody in the state of Maryland.
So I'll say this, I mean, that from my client's perspective, maybe on the opposite side, right? They're asking me, like Rebecca, it was not my client, but is asking then her lawyer, why am I being non-renewed? Why are they terminating my lease? I'm paying the rent. Why am I being non-renewed? And so for them,
So
this
what,
bill
what
is...
would be the answer back to her?
The answer back to Rebecca was that it really, in my opinion, was retaliation, that this landlord was...
But as a contract lawyer, and I am not,
okay.
I would say that you're at the end of your contract.
Yeah, I mean, so...
Anecdotally, we can come up with why we think that, and we can think that they've been violated, but at the end of the day, their contract was ended.
Sure.
So I don't know.
The state regulates contracts for all sorts of reasons, right? I mean, we don't allow child labor, right? We put restrictions on what contracts can say and what they can do. On the non-renewal piece, I'll say that in the labor agreements, there's often a for cause provision. I think state law regulates insurance contracts and says that an insurance company can't just drop you except for cause. So there's certain compelling reasons where the state determines, wait a second, there's a power imbalance in the market. And so we need to correct that imbalance, as have, again, 8 states and over 23 jurisdictions, to say, well, let's provide at least some transparency for renters in that equation. On your point about corporate landlords, or what we're trying to get at is the landlords who are in the business of landlording. So if you just have 1 or 2 investment properties, you're not in the business of landlording. And to be clear, this is a compromise. We you know, on my side, we'd prefer a much smaller exemption, something that mirrors the Fair Housing Acts. But this was a compromise provision put in by the House to try to strike that balance between people who may not be in the business of being a landlord and people who have a substantial business in being a landlord and are treating it as a business. I'll just say, too, lastly, on the contracts, that over 210,000 rental units in the state already have good cause. And that's from the low-income housing tax credit. It's from other forms of public subsidy. And so it's not a new idea in the space of rental housing.
Right. But those people have chosen to take public money. You choose to take public money, you're going to have to deal with the policy that deals with the people's money, the state of Maryland's people's money. If it is an individual who is not choosing to take it, I just don't understand. And I'd love to see examples of contract law that we have where it's, it just seems like we're muddy in the waters. But thank you, sir. And
thank you.
We will continue because you and I have always had a good relationship, and I appreciate you, sir.
Appreciate you, Senator.
Thank you, Mr. Chair. Mr. Hill, I'm responding to a comment you made a few minutes ago. That's why I put my light on a second time. So a couple nights ago, I had dinner with a Democratic delegate from Montgomery County, but I'm redundant because they're all Democrats in Montgomery County. We were talking about housing in Montgomery County and rental housing in particular. And he pointed out that in the independent municipalities of Gaithersburg and Rockville, there are lots of rental housing projects underway, being constructed. Because, he said, Gaithersburg and Rockville aren't subject to the rent control and vacancy control of Montgomery County. We had this fellow last year come and say in Montgomery County that there's no construction going on. So is it your contention that the controller's report, which has been cited repeatedly, draws a distinction between that would explain why there's construction proceeding in Gaithersburg and Rockville, but no construction proceeding in the rest of Montgomery County?
So, Senator, if I could defer to Dr. Howell on this particular question around development, but I'll say correlation is not causation, and that's why we need the research by folks like Dr. Howell.
Okay, Dr. Howell, well, you've talked about in general about you don't think. Well, you answered my question earlier on. Can you explain the why there is construction going on in Gaithersburg and Rockville, but not in the rest of Montgomery County?
Sure, and folks in the district are asking the same question, right? They're like, well, there's building out elsewhere. Part of it is land costs and land availability, right? There is a question of zoning, and I do think it's important to zoom out a little bit on your timeline for this.
So wait a minute, you're saying in Rockville and Gaithersburg, there's lots of land available.
There's more land
But
available.
not in the rest of Montgomery
There's
County.
more land
It's
that's
all-
affordable.
What's
right?
that?
There's more land that's affordable. The closer you get into the DC area and closer you get to the Beltway, the more expensive land tends to be. And so it is actually a critical issue. The other part is the question of zoning, which we haven't really discussed here, but that's part of land availability and land affordability, right? If you don't have land that's zoned appropriately, or the land that you do have that's zoned appropriately is one of very few parcels, then you're going to have a real challenge of actually constructing anything on that property. Because I think what's important to note is that rent stabilization in Montgomery County doesn't kick in until 23 years, I believe. I believe it's 23 years, right? And so I'm not sure how that impacts current development, right? If you aren't actually subject to that law for 23 years, and most people who are building, frankly, are disposing of the property to somebody else before that, and by that point it becomes a more affordable property typically anyway. I just think that's an important point to make here is that we look at that and we say, oh my God, it must be rent control, rent stabilization. And at the end of the day, right, that's 23 years from now. And that's a really long time in the life of a building.
Okay, thanks for your answers.
I'm not, again, just to provide friends, I mean, like for the 23 years thing, I mean, like when you are financing a deal, your lenders are going to look at short and long-term ability to recoup and pay. So just like if you had a 30-year mortgage, and if something kicked in halfway through that 30-year mortgage, your ability to fundamentally change your ability to pay, a financer is going to look at that and understand when you're stacking and creating deals to finance a deal. I'm just, in all fairness.
Absolutely, and I would also say that like part of your pro forma, this actually gives more predictability to a pro forma, right? Because right now we assume massive rent increases over full time. And I think what we found actually is that doesn't always pan out and then the buildings get into trouble. So in terms of stability of housing over time, having predictable rent increases is a really powerful tool for actually developing a pro forma. So, sorry.
A cap on predictable rent increase. A cap on the increase.
Yeah, cap on increase. So it's usually, I think in Montgomery County, it's CPI +2.
Yeah.
Three. Oh, CPI +3.
And then the vacancy control, you can bank up to 10%, I think. Yeah. Okay. All right. So I'm going to just, because I want to make sure you all have an opportunity because you're not going to have a chance to rebut. So then, personally, I've talked to you about this before, Matt, at least, that I don't think that good cause is going to quash development, or I really don't. I mean, I think it's actually pretty much in line with what a lot of developers or landlords, like I think your interests are aligned here in the sense like you want people to stay in a unit because it's more difficult to flip a unit and invest in all those improvements. You want predictable income and you want people who are good tenants. Like those interests are aligned. And so I've always said this. So I want to give you an opportunity to rebut this argument because it will definitely be made in the subsequent panel. Is that when you have a jurisdiction, let's say like Montgomery County, and you've layered on top vacancy control, rent control, this, that, and the other, you've created a regulatory scheme and environment that creates a non-permissive environment for development. Can you just talk to that? And I think you've engaged in a little bit of that, but it's not this thing alone, but it's this, that, and the other together that creates a non-permissive environment. Can you just speak to that? Because it's going to come up in the next panel.
So two things. I think I've actually already responded to this question about 3 different ways, right? Which we have talked about is that the research doesn't bear this out. Our neighbors, it doesn't bear this out. In our anecdotal data and our larger studies, it doesn't bear this out. I would also say it's like saying, is it the recession? Is it interest rates? Is it the fact that we're deporting our largest labor supply? Is it the fact that insurance is doubling in some buildings, and some buildings people are getting dropped from their insurance for multifamily buildings? I don't know. It's hard for me to say that the reason why we can't build is because of tenant protections when there's all these other things that have been going on. So for me, I think that sort of saying, yeah, it's a regulatory environment, sure, but that doesn't actually play out anywhere else. So I think that's actually, to me, is a really important question, and that the larger context matters, right? I would love to be able to change the fact that our agencies are being cut and that our people are being deported. We can't do that. But we can try to make their lives as stable as we can, right? And that means that we need to have stable and predictable rents, not rent, this isn't Friends, we're not living in a 3-bedroom, $300 apartment. It's rent stabilization with predictable increases. It's knowing that if you follow the rules, you can stay in your apartment. And every landlord I've ever talked to, truly, whether it's a small landlord or a large landlord, the good landlords say, I want a stable tenant. I love good tenants, and like that's why I stayed in my apartment for 6 years. My landlord loved me because they were like, yeah, you're great. You call when there's a thing. You don't break the rules. So this is actually in reinforcing what good landlords are interested in. I think that's really, really important. And so, you know, I can answer it six other ways, but to me, these are sort of the larger context pieces are very important.
All right. And just briefly, if I could add to that, again, to follow up, again, the comptroller's report talks about land use, zoning. These are the regulatory decisions that are stymieing new affordable housing development. That's what's cited in all the reports and all the research. You'd be hard-pressed to find any research that says good cause eviction plus rent stabilization with a 23-year new construction exemption, you know, decreases the new housing supply production. It doesn't exist. And yet, let's just be honest about what's happening here. The landlord industry, the corporate landlord industry is coming out and they're seeing affordability as the new buzzword. And so let's undermine, you know, tenant protections we don't like in order to blame it then for the lack of affordable housing and the lack of new housing development. That's what I see from my vantage point. Thank you.
All right. Further questions from the committee? Senator Sidnor, you're thinking hard over there. What's going on? Okay, excellent. All right, thank you, Senator, and thank you to the panelists. With that, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel, and we have Mr. Anlu and Mr. Etten.
Mr. Chair, I'm going to sit here because Bob asked me to help him with his opposition to this bill. So I'll sit here with him.
So all this is yours.
Yeah. If you need me, call me. No, that's not mine. No, that's mine.
I thought it was his.
Yeah.
There's more to it. Good afternoon, members of the committee. Robert Enton on behalf of the Maryland Multi-Housing Association. You know, I've represented the residential property rental trade associations, I guess, for, I don't know, 30 years, 35 years. And I've seen a lot of things come and go in that time. We are vehemently opposed to this legislation. The first bill that we saw on this was introduced in 2018. It was a Montgomery County local bill. It did not pass. And there has been a bill every year since then, and no bill has passed. So what this legislation does is it punts it and says, okay, we can't get a bill passed in Annapolis. What we're going to do is pass this bill, and then every single county in the state can adopt their own version of it. We're strongly opposed. The builders, you have testimony from the Maryland Building Industry Association. They're strongly opposed. They're the ones that build these buildings. When you look at the bill, there are so many flaws in it, in my opinion. This whole thing about trying to figure out who owns the property, the term of art that I heard was jack up the rent. We don't jack up the rent. We increase the rent because, you know, we're business people, just like anybody else increases the cost of their services. What I guess upsets me the most, and I'm almost out of time, is that when you look at this notion that this is just about disclosing what the cause is, and I hear that every year. That's not what this is about. This is about creating a situation where when a contract is up, I'll wrap up. When a contract is up, you, unlike anything else, maybe it's in a labor agreement someplace, I don't know, but I can't think of any contract out there, a business contract with the public that says that you can't walk away.
Mr.
If we can't walk away, why can the tenant walk away?
Excellent. Thank you very much. I'm sure you're going to have questions to answer.
Okay, good.
Your testimony. Thank you very much. And also, we've got some pages joining us, welcome. And if there are any pages in the audience, you can come up and sit up here if you'd like. You want to get a better side. Senate pages, even the House pages are welcome over here too, but that's cool. All right.
All right, good afternoon, Mr. Chair, members of the committee. Brian Anley with the Apartment and Office Building Association. I want to address the layering of good cause on top of local jurisdictions. Senator West has referenced the testimony you heard last year from Chris Brew with the Donahoe companies about the impact that local regulations are having on new construction in Montgomery County. We now have more data showing that housing permits have dropped 96% since rent control was enacted in Montgomery County. Montgomery County has early vesting, by the way, and they've upzoned areas near the metro, and this is not a land use issue in Montgomery County, despite what you heard. The numbers aren't much better in Prince George's County, which also has rent control. At the same time, Northern Virginia and D.C. have managed to build thousands of units. D.C., by the way, has an exemption from rent control. It's a fixed date exemption from the 80s. They never changed it. Anything built after the 80s, rent control does not apply there. The proponents would have you believe that regulations do not have an impact on new construction, but that's simply not true. The Montgomery County Planning Department surveyed developers last year with development approvals, meaning they could go and get building permits to build, and they found that vacancy control was the #2 reason that they are not building in Montgomery County. Vacancy control institutes rent control for vacant units. It is not an affordability tool. The only way to make housing more affordable is to build more supply. But you can't build more supply if you have a policy in place that prevents that supply from being built. We simply can't afford to have both vacancy control and good cause at the local level. And I'll conclude by saying that last year we came to the table with a path forward for how to address this issue, including prohibiting a county from having both vacancy control and good cause, and the proponents oppose it. So for those reasons, I respectfully urge an unfavorable report. Thank you.
Senator McKay and Senator West.
Thank you, Mr. Chair. Mr. Enton, just wondering if you could continue about kind of answering my question about contracts. Are there any other where the date ends, but yet we've got this ability?
Okay, so I've been practicing law since 1973, okay? And I'm not aware of any business-to-business contract or business-to-consumer contract, any, where when the contract is over, one of the parties can decide and make the other party keep it in effect. And it always gets under my skin when I hear that this bill is just about giving a reason. That's not what this bill is about at all. This bill is about saying that at the end of this contract, you can't terminate unless you meet one of the following conditions. And I believe that is unprecedented. It's unprecedented in statute. I would love to see a statute in the state of Maryland that has a clause like that. I've never seen it.
If I may.
Uh-oh, I'm going to get a question now from Senator Love. I shouldn't have said that, I guess.
So, so I've read some of the other testimony of who are not in favor of this, but some of the regulations are already within HUD and the federal good cause holdover provisions. Can you speak to that, as in, because it says here, as such, the landlord is subject to different HUD rules, including rules of inspection, lease agreements, and other matters.
My understanding is, and I think you were absolutely correct in what you said, is that if you're going to accept public money, federal money, or the tenant is going to get federal money to help the tenant pay the rent, yes, then there are some of those requirements. Just so I don't forget to say that you do have opposition from the judiciary as well. My understanding that was filed today. I have a copy of that, but they were opposed to the bill last year, and they are opposed to the bill this year. Very unusual.
Can I speak to the HUD thing? Can I speak to the HUD thing?
Can you shed some light more on the HUD to answer my question?
Yeah, Senator McKay. So my understanding of the way the bill is drafted, that it would go even beyond what HUD requires in its good cause requirements. And that's why I haven't seen the bill file, but the Maryland Affordable Housing Coalition actually came out against good cause because they have LIHTC properties that receive HUD funding that are already subject to good cause. And this would add an additional layer that they would have to be burdened and comply with on top of HUD's regulations. So it's not simple just to say, oh, HUD already has good cause and all these folks are operating under good cause. It's a step beyond that.
Last one, if I may. So did either one of you, I had asked one of the previous witnesses to define corporate landlord. Does either one of you have any thoughts on said answer? And then do you have either maybe an amendment idea where I believe I gave a good example of small landlords who are just trying to not be a corporate landlord. So I'm open to any of your comments for that.
Well, let me just say, I mean, in the context, it makes it sound like, oh, if you're a corporate landlord, you are inherently evil. And, people form corporations to go into business. Some of the members of this committee have formed corporations to be in business, or witnesses, law firms, vendors, whatever. You form a corporation. What's interesting about this piece of legislation is that it puts requirements on to say that when you talk about who has to comply, it says the name of each individual and the business name of each entity with a direct or indirect ownership or membership interest in the residential rental unit. So what does that mean? If I'm a corporate landlord and I've got 5,000 stockholders, I have to give all this information about each stockholder. Where else in the Maryland law do we put that on anybody? All I do is, every day when you open the newspaper and I open the newspaper and they talk about priorities in Annapolis, what's the number one priority that you read about, other than redistricting, of course? And that's housing. That's housing. And I think in response to some of the questions that we've gotten is that you put yourself in the position of someone that wants to own rental properties in the state of Maryland, and you see whether or not this legislation and some of the other legislation we see incentivizes people to go out and buy properties and lease them to people. The answer is no.
And my rebuttal, go ahead, sir.
I would simply add to Mr. Enden's point that corporate landlord, and as someone who represents corporate landlord, is a very broad term, and it includes housing authorities, affordable housing providers. It's very broad. And I'll also say, and this sort of came up earlier with how different counties address these kinds of issues, both Montgomery and Prince George's counties laws apply to, the rent stabilization laws specifically apply to people who own 4 units or more. So that's sort of another difference in between this and what we're talking about there. In Prince George's County, they make a separate exclusion where if you live in the county, you can be a corporate landlord and have multiple properties and not be impacted by some of these different laws and regulations. So it's sort of all over the place, and I don't think there's any one good definition, but it really lumps in the bad actors with the good actors.
Thank you. Thank you, Mr. Chair.
Thank you, Mr. Chair. Hi, Bob. How are you?
Well, we'll see.
No. But I do want to pursue this issue that you keep bringing up about, you keep saying this is the only area of the law where this can happen and this is unfair. So can you show me another area of the law where there's a contract that affects your family stability, your schooling, your access to community, your access to work, where it is generally extended and often extended, but then can be canceled often as a pretext without any reason for retaliation? And I don't want to hear about retaliation. I want to talk about an example of a contract that is so big like that has such importance. And clearly my underpinning here is this is very different.
So, that's a good question, Senator. let me say that, first of all, current Maryland law prohibits retaliatory evictions, okay? In a very broad fashion, and in particular for your county, there's a whole separate section in the Maryland law that's stronger than what applies to everyone else. So there are already prohibitions against retaliatory evictions. That's number one. Number two, I can't, and I'll look and I will get back to you, but you know, I have a broad list of business groups and businesses that I represent down here. I've dealt with the consumer laws in the state of Maryland for various different types of entities, builders, landlords, bankers, whatever. And I still can't think of a single section of law that deals with consumers in Maryland where at the end of a contract, either party can't walk away.
But that wasn't my question. That wasn't my question. And I did say, let's not talk about retaliation.
Okay.
So my question was, can you tell me any area of law where you have a contract that affects all of these things, that is so core to a family's stability and access to community and access to schooling and access to work, transportation, all of that?
Okay, well, the chairman maybe just got a copy. He just picked up a volume of the real property article. The real property article is pretty darn thick. It covers landlord-tenant. It covers foreclosure. You name it.
Sure.
Okay.
And we also know that, and I didn't want to go down the area of retaliation because we can have a discussion about retaliation and why it doesn't work in certain areas and how we have seen people use this. And I'm not painting anyone with any broad brush here. But the point was that this is such a different situation. Just to say I've never seen any other contract is really not getting at the context that we're talking about.
Okay, well, let me just respond directly to that and to say that we have extensive page after page after page of regulations of landlords and of residential leases. We have pages and pages and pages in the commercial law article, and most of those bills go to Senate Finance, that regulate consumer lending. So, you know, different areas of business are heavily, heavily regulated under Maryland law. And we're not saying that landlords shouldn't be regulated. What we're saying is that this bill in front of you is deeply flawed, okay? And to say that this is about giving a reason, that's not what it's about. And it's about saying that putting the burden on a landlord when the contract has ended, and for whatever reason, you don't want to continue with that contract, that you don't have the ability to walk away. The burden is on you to go to court and prove that this tenant fell into one of these categories. And when you look at the terms where it says habitual and uses different terms, who's going to, you know, how do you determine whether or not you fall into that bucket? And if I have a tenant that's a problem tenant and makes noise and puts the trash out in the hall and everything else and has offended his neighbors, what am I going to do? Am I going to summons them into court? If I want to walk away from the lease, what I'm going to do is wait till the lease is over and not renew it. That's my option.
And it would that example would fall under the good cause. But thank you. Thank you, Mr. Chair.
Thank you, Mr. Chair. So, Mr. Anlu?
Yes.
Anlu. We sat for quite a while listening to the professor talk about how her research has convinced her that all these anti-landlord bills were pieces of legislation that we've passed since I became a member of this committee in January 2019, as well as the separate legislation passed by the County Council of Montgomery County and Prince George's County, that they really have, they're not the reason why people aren't building rental housing in Maryland, but there are other reasons. And for the first time, you cited some statistics, but you were trying to cram them in your 2 minutes. Could you go back and give us statistics? I think the one I remember most specifically was Montgomery County. Since I got on this committee in 2019, what was the percentage reduction in applications for building permits for multifamily housing in Montgomery County?
96%. And if I could, Senator West, very briefly, just sort of touch on some of the research. I'm not sure that the academic study that was presented is a good example or even necessarily relevant to Montgomery County. As you heard from Chris Brew last year, who's a local developer in this region, he's not a national guy. He has, as a developer, the option to develop in Montgomery County, he can develop in the city, or he could develop in Northern Virginia. And that's what we're talking about here. We're talking about jurisdictions in close proximity to each other that are competing with one another for capital dollars, for investment, for new housing construction. And some of I think the other studies that were looked at, they don't necessarily look at those jurisdictions where across very close lines, there are two very different regulatory frameworks and how that impacts the development. The second point I'll just briefly make is last year, our national affiliate had a study. We presented it to the House Economic Matters Committee this year on, it was done by a firm called MetroSite that looked at the impact of landlord-tenant regulations on housing affordability. And the study concluded unequivocally that not on the building side, but on the cost side, that having additional landlord-tenant regulations raises costs for landlords and therefore makes it more burdensome, more costly to operate and less affordable for the tenants, because it creates things like vacancy loss, it increases legal costs, as Mr. Enton has pointed out, and a number of other different things. I'm happy to get you that study as well.
Okay, that was my next question. Could you please provide me with a copy of that study?
Yep.
But I'm more interested in these statistics. So this 96% reduction in applications, that's over a period of what?
So that one specifically was from when rent control took effect in Montgomery County in the fall of 2024 through August 2025. So just to give you a little bit more context, because I think the percentage maybe obscures.
So in just a year?
In just a year, but it was looking at that percentage specifically looked at over time how much of a drop off the county has essentially seen in new building construction. And you can make a comparison of before rent control's enactment and after rent control's enactment, and you can see that there has been a steep drop off. The county's own economic indicator reports have this data. So it's not something that the landlord industry is making up. It's something that the county's own data can show.
Now, you started to give us statistics on Prince George's County, but again, I think because of your time limitation, you quickly went through those in no detail. Do you have more specific statistics of Prince George's County along the lines of the ones from Montgomery County?
Yeah, so not in percentage terms, but just very briefly. So Montgomery County from October 1st, 2024 to August 31st, 2025 had 54 new building permits. Prince George's County had 233. In the same time period, Fairfax had 2,000. Washington, D.C. had 1,700. Arlington, 1,500. Loudoun, 1,200. Howard, 500. Anne Arundel, 500. And so, you know, we can talk about the land use and the vesting and all of those things, but I was the former chief of staff to the planning board. I know a thing or two about land use, and I can tell you that we have made it as easy as possible to build in Montgomery County, and builders are still not building.
Rockville and Gaithersburg, did you separate those out because they're not covered by the Montgomery County rent control ordinances?
I do have numbers on Rockville. I'll caution that Rockville and Gaithersburg are small jurisdictions compared to all of Montgomery County. I mean, they are tiny, and they do have projects that are moving forward. Rockville had, according to these numbers, it had 48 permits over that year. But again, it's a tiny jurisdiction where you might only see a handful of projects move forward at any given time. You might see 1, 2, maybe 3 projects.
And the professor told us that the reason why there's no permits are being issued for Montgomery County is attributable to zoning laws and things like that. Do you have any comment whether you think that should be relied on, that answer should be relied on?
I'd respectfully disagree. As I said, in my former life as Chief of Staff to the Montgomery County Planning Board, and not speaking on their behalf, just from my experience, we've done all sorts of things to increase development in the county. Density bonuses in our downtowns. We've upzoned all over the county, North Bethesda, Silver Spring. They've all received considerable upzoning to build the dense type of housing that the county would like to see to house its workers.
So you're saying there is land in Montgomery County available for rental construction if the prospective landlords wanted to build, correct?
Yeah, there is. And I would say DC is much more built out than Montgomery County, and they're still building rental housing in DC. So that's just an example of land itself is not the constraint, and land use and zoning is not the only constraint. It's all of these other landlord-tenant policies that layer on top of each other and create a hostile environment to new investment.
And finally, in your opinion, if we have rent control and vacancy control and layer on top of that this good cause eviction requirement, what do you think the effect of this is going to have on the community of people who are in a position to, if they want to, borrow money in order to construct more rental housing in Maryland?
I think it's going to make it more harder for them to do so. It's just going to make Maryland and those counties that enact this policy that much less attractive to national investors, to people who are hoping to get a return on their investment through these development projects and are fearful that these policies will impact those returns.
Thank you.
Thank you. Mr. Anlew, no, I don't need you, Mr. Anlew, I would like to speak with you, just ask a couple of questions. I'm going to leave Mr. Anlew alone today. You had noted earlier, you said MAHC is opposed to this, but I didn't see testimony in opposition.
It's under Maryland Management.
Tom Cole, and it says that? Thank you. The next question that thank you. The next question that I had, I'm trying to understand because I was looking at, I believe it's Councilwoman Mink's letter, and I'm wondering, I mean, she has a lot of local officials who are saying that they want this. They want this authority. What would be what's your argument if I were to say, if they want, because, and this is from what I'm hearing from you, if we give this to them, essentially their economy in apartments is going to go to the tank, right? If they want to do this, then why should we stop them? I mean, because I represent Baltimore County. I would love for the market then to come to Baltimore County. So if they want this, I mean, everybody wants to be competitive, but they're asking for it, so why should we not give it to them?
Hold on here. Is your argument that Montgomery County goes down?
I'm
Baltimore County.
Well, I'm happy to answer.
Save ourselves from ourselves. What do you say,
Mr. Chair? I'm happy to answer that question. One of the benefits of my job is that I get to work on both the state and local level. So I had a firsthand experience to the county's passage and enactment of its rent control law. And one of the things that we heard at the time, and it wasn't us that was tying these two issues together. It was the proponents. Some of the same people that you've heard from today and that support good cause stood up and said, sort of what the chair was alluding to, which is that if you don't have good cause, there's a perverse incentive to not renew a lease in order to get back to market rents. That firstly ignores how rental housing works. But putting that aside for a moment, what they said at the time was, if we have good cause, we will revisit vacancy control. Now what they are telling you is, we need good cause and we need vacancy control because we believe vacancy control is an effective, affordable housing tool. And so it's sort of like, which is it? And they're moving the goalpost. And again, to the point I made in my testimony, vacancy control is a poor tool to address housing affordability. The best way to address housing affordability, which we also presented last year, was to build more housing, was for new supply. And you can't get that supply if you have too many regulations in place like rent control, like good cause, and other regulations that prevent it from happening.
I'm looking at the testimony now from Maryland management, I'm still not seeing where it says MHAC. Is that, and I know Mr. Cole represents MHAC as a lobbyist, but I'm missing it. Is it in there?
Specifically what I said in my oral testimony was last year they came out against it. They even wrote an op-ed. I wasn't sure whether they opposed it this year or not, or whether it's in the bill file. I can follow up with them on their position. I'm happy to get back to you on that. I certainly do not represent the Maryland Affordable Housing Coalition, and I'm not speaking on their behalf. I was just pointing out to Senator McKay's question that one of the reasons that they were opposed to it, at least last year, was because of this going beyond the HUD regulations. So again, I'm not sure what's in the bill file. I'm happy to follow up with them.
All right, okay.
I could just comment, Senator, on your question, and that is, as far as the local jurisdictions, the only local jurisdiction that ever put in a bill was Montgomery County, and it was approved by the Montgomery County delegation. It never passed, and so we have the bill in front of us today, which is another way to get there. But MACO has never come in and supported this bill. I've never seen anybody from any other county come to the table to support it.
But MACO is made up of they're the voice for a number of different local governments. These are local government officials themselves. And in some cases, you have executives who are saying, we want this authority. Yeah. So let me flip this a little bit. I would assume it would be more beneficial for your members not to have this type of bill pass where you have possibly 24 different jurisdictions passing their own versions rather than us doing it at the state level, right?
Well, it all depends on what the bill says. Come on now. I got what's in front of me. And once again, I mean, it just strikes me as interesting. And I saw Judge Marcy was here. You know, the judicial branch is against having these 24 different laws. And,
right, that's what I'm saying.
And how often do they weigh in?
So what if we were to modify it and just have a one blanket state law?
Well, if you have a statewide bill, I'll still be here opposing it, believe me.
That's what I'm trying to understand. Thank you.
If I may, just speaking for AOBA here, look, one of the reasons that we did come to the table last year and try to work out a compromise on this issue is sort of what you're hitting on here, right? And I think while we're unfavorable, what you're hearing from me at least is that, you know, we, from AOBA's perspective, want to sort of figure out how to make this work. And really, you know, in our view, because of the vacancy control piece specifically, we don't think that these two laws work well together. And so that is sort of the main hang-up here. And that's, I think, ultimately what this body needs to decide.
Yeah, and let me just say, don't get me wrong, if we can work out a compromise, a statewide compromise, that would be great. I don't know if we can do that or not.
Thank you. Gentlemen, you mentioned some statistics, and the time frame was, I think you said 23 to 24.
Yes. Well, since the enactment of the rent control law specifically, 24 to essentially through last year.
How do you get accurate, correct information in 1 year?
Well, again, this is the county's own report. So they're relying on their permit numbers that the county's reporting. And, you know, I mean, I have no reason to doubt that the county's reporting. In fact, if anything, the county executive would want the numbers to look better than they are. And so what you're seeing is the drop off over that time period.
Okay, thank you. Well, I guess there goes my banking job. Huh. There goes my banking job. Yeah.
All right, further questions? No, look, we'll just end here. Like I said, I've said this a million times. I don't think good cause, you know, is going to kill the housing market in any jurisdiction that adopts it. I mean, I think that the incentives are aligned for developers and for tenants and landlords on that issue. I do think, I mean, I do like the example of like, you know, a pension fund though, in terms of investing in new housing and building new projects, because we talked about the dearth of housing and our need to do it. Pension funds are a very good example because the people that hold pensions, like your teachers, your firefighters, your police officers, people that are core members of your community, have a pension fund, and they're going to rely on that for their retirement. pension funds look for investment opportunities to make a return so they can pay out the pensions. Increasingly, housing is becoming an attractive asset class because there's a strong demand signal. But they're only going to enter the marketplace if there's some semblance that they're going to get a return. So, and that's fair. We live in a capitalist democracy, so that's fair. So for the local folks, and I see one member of the council is running for county council. I'm talking to you all. We passed this bill just making sure when you are having the debate at the local level, the housing market is giving you bright, flashing yellow lights, just to be careful. And so my only thing is, if this bill makes it to you all, just be careful in the other regulations and things that you're discussing at the local level, because the housing market is doing something and there's a bright, flashing yellow light going on. And so we give this enabling legislation to the locals. I'm just asking to have an informed, well thought out conversation, which you always do. And that's my last word. Isn't that so? Thank you all very much. All right, with that, that'll conclude the hearing for Senate Bill 462. We'll now move on to Senator Muse. Hey, Senator, we accidentally grabbed your binder here. 463, Senator Muse.
Okay, Mr. Chairman, Vice Chair. For the record, I'm C. Anthony Muse, representing the 26th Legislative District, and I'm here today in support of Senate Bill 463, which repeals the authority of municipalities to prohibit vacancy. On my panel with me today, I have Kristen Downs, Maryland Office of the Public Defender. SB 463 does one very specific thing. It removes municipal authority to prohibit vacancy. It does not eliminate safety laws. It does not excuse criminal behavior. It simply ends the use of vague and outdated that targets people for who they are, not what they do. A concern for me is that instead of addressing harmful conduct or committing specific crimes, vagrancy laws criminalize status, poverty, and homelessness. These laws are outdated and have been enforced inconsistently across municipalities. They have historically been used to target people who are unhoused or simply present in public spaces without resources. The approach does not improve public safety. It pushes vulnerable people deeper and deeper into the justice system. 463 does not weaken local authority. Municipalities will still be able to enforce laws related to disorderly conduct, nuisances, public safety concerns, and other conduct-based offenses or criminal activity. This bill removes only the authority to prohibit vagrancy, not the ability to address the misconduct. Criminalizing poverty does not solve homelessness. It creates barriers to employment, housing, and stability. It ultimately makes communities less safe. We're seeing increasing pressure on local governments to respond to homelessness with enforcement rather than solutions. Public safety is strongest when the law targets behavior, not circumstances. Senate Bill 463 brings Maryland law in line with constitutional principles and modern best practices. It imposes no cost to the state and preserves municipal tools to maintain order, and it's for this reason I respectfully urge a favorable report on Senate Bill 486, 463.
Good afternoon, Chair, members of the committee. My name is Kirsten Geddes Downs. I'm a Director of Systemic Reform at the Office of the Public Defender. And we would ask this committee to issue a favorable report on Senate Bill 463. The Maryland Office of the Public Defender represents those that cannot afford counsel. Our clients are overwhelmingly poor, disproportionately Black, and disproportionately unhoused or considered housing insecure. The vagrancy laws, by definition, criminalize that status. They do not criminalize behavior. They punish people for wandering, for not having a home, for being visibly poor without means of support. That means a person can be swept into court not because they've harmed anyone, but because they are poor in public. That means a citation or arrest for nothing more than sleeping on a bench when every shelter is full. For our clients, that arrest record can make it harder to find work and housing, depending on the very conditions that give rise to the charge in the first place. Historically, vagrancy laws have been inseparable from racial control. They are a core component of the Black codes and Jim Crow laws that were used to arrest Black people for minor and status-based infractions, funneling them into convict leasing and coerced labor. That legacy still shows in the data. Black Marylanders are approximately 1/3 of the population, yet approximately 60% of the unhoused. When we criminalize homelessness, we invariably worsen racial disparities. This is ultimately about fairness, about using the criminal code for conduct that actually threatens public safety. 463 is a carefully targeted reform. It removes municipal authority only to prohibit vagrancy while leaving intact the other tools local governments have already had to address public safety concerns. For these reasons, the Maryland Office of the Public Defender respectfully asks the committee to issue a favorable report.
Excellent. Thank you very much, Ms. Downs. Questions from the committee? Sounds, I'd say that your testimony kind of hit hard because I was asked a little bit earlier about the, we have legislation to look into the Cheltenham, the grave sites there with the former, in the 1800s where they built the juvenile detention center there and a number of Black boys, up to 300 they think now. And they're going through the records, and one of the #1 charges that they're being committed for is vagrancy.
Absolutely.
And those kids were leased out for labor.
Absolutely.
It was just contracted out labor.
And vagrancy, and as historically showed, this is one of the major tactics in which people were detained, and that continues to today. I was told not to, but I feel like I want to start all my testimony with Harriet Tubman left Maryland for a reason. And so we got to do better. We got to make sure that we make these changes and so that those legacies get changed over time.
Yeah. I just wanted to share that with you. Thank you for that. Any other questions? All right. Thank you very much. Good bill. Thank you very much. With that, that'll conclude the hearing for Senate Bill 463. We'll now move on to Senator McKay with Senate Bill 477.
Awesome. They have, they said, and I told them, patience is a virtue that helped the blind squirrel find the nut. So much profoundness from the eye candy of the General Assembly. If they can't find you useful, maybe they can find you humorous. Anyhow, I might get accused of being like another senator talking in the third person. But anyhow, I'll leave that at that.
Thank you, Mr. Chair. Thank you, committee, for allowing me to present Senate Bill 477, Civil Actions Real Estate Appraisal Statute of Limitations. Now, this bill's primary purpose is to establish a specific statute of limitations for the civil actions involving real estate appraisal-related services. It provides much-needed clarity for the professionals by defining exactly what the window of filing lawsuits begins and ends. The defined appraisal activities, the broad inclusion, is that the bill covers all analyst conclusion and the opinion related to the nature, quality, utility, and the value of the real estate. Specific assignments include the valuation appraisal, analyst assignments, and the review of said assignments. It is a clear exclusion that specifically excludes the opinions on listing or purchasing prices provided by the licensed real estate agent brokers, provided that the opinions are not labeled as appraisals. It's a two-pronged filing deadline. The bill establishes whatever comes first deadline for filing a civil action, whether talk about the discovery rule within the first 2 years when a complainant knew, that means they should have known, that the alleged act or omission. And the statute of repose, regardless of discovery, an action must be filled within 4 years to the date of the appraisal service that should have been provided. This particular bill, just some of the facts related to Senate Bill 477. Appraisers currently are only required to keep their work for 5 years. Also, please note the fiscal note does not anticipate any state or local fiscal impact. This bill does mirror a Florida piece of legislation back in 2023, House Bill 213, and we would be the 17th, I believe. There are 16 other states that do have limitations, periods rating between 1 and 6 years. We do prefer the bill passed in Florida, but I can provide you with some of the ranges of those different states if you like. And my panel, I'd like to turn it over to my panel unless there is a direct question for me at this time. Thank you. Please, Mr. Wood.
Chair Smith, Vice Chair Waldstreicher, and members of the Senate Judicial Proceedings Committee. Good afternoon. My name is Matthew Wood, SRA, and I am a certified residential appraiser based in Hancock. I'm appearing on behalf of the Appraisal Institute in strong support of Senate Bill 477. I want to thank Senator McKay for sponsoring this important legislation. At its core, SB 477 is about fairness and common sense. An appraisal is an opinion of value as of a specific date and time. It is not a warranty of future market performance, nor a guarantee that a loan will perform. Yet under current Maryland law, appraisers can face lawsuits many years after completing an assignment, often long after required record retention periods have expired. When a loan defaults, particularly during periods of market stress, the appraisal often becomes a convenient target, even when the default is caused by borrower's circumstances or broader economic conditions that no appraiser could predict or control. Lenders are required to conduct a substantive review of appraisals at origination. Too often, however, that review is reduced to a cursory check of the value conclusion. If deficiencies exist, they should be identified then, not years later after a loan fails for unrelated reasons. SB 477 preserves a 2-year discovery period for legitimate claims while establishing a reasonable 4-year outside limit for when the appraisal service was performed. That certainly is critical for small appraisal businesses managing risk and insurance costs. The bill does not shield fraud and does not limit regulatory oversight. It simply ends indefinite exposure and ensures claims are brought while evidence is still available. We respectfully urge a favorable report on Senate Bill 477. Thank you for your consideration.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and committee members. For the record, my name is Scott DiBiasio, and I'm here today on behalf of the Appraisal Institute in strong support of Senate Bill 477. I'd like to thank Senator McKay for carrying this bill. I don't have a lot to say beyond what has already been said, but I do want to point out that this bill is very similar in nature to the law that establishes a specific statute of limitations for land surveyors. I'll read. No cause of action for damages accrues, and a person may not seek contribution or indemnity for damages incurred for an error in a survey of land unless an action for damages is brought within 10 years of the survey or within 3 years after the discovery of the error, whichever occurs first. We suggest 5 years for appraisers to match the record-keeping rule of our professional standards. As Senator McKay pointed out, there are 16 other states that have enacted similar legislation, similar laws. There are 4 other bills pending right now, and one of those bills is sitting on that state's governor's desk. I did find one minor technical issue with the bill this morning, so we'll be working with Senator McKay and committee staff to draft an amendment. It's very simple and straightforward. With that, I'd ask for a favorable report. I guess it would be favorable with amendments on Senate Bill 477. I appreciate the opportunity to be here, and I'd be happy to answer any questions.
Thank you, Mr. Chair. And I'm going to ask the questions of your panel. Yep. So the Brookings Institute did a study some years ago, and it talked about the racial impacts on our communities with racial appraisal bias. And it showed that there was over $156 billion in lost generational wealth because black homeowners have lost so much because of the racial appraisal bias. Homes being undervalued 23% or more in comparison to white homes. So much so that black homeowners have done what they call whitewashing of their homes, taking all the black pictures down and putting white pictures in their houses because they believe the house will be appraised more. And it has. They have shown study after study after study that when that has been done, the houses have appraised a lot more. And so one of the problems that I see with the bill is that it's not always understood at the early stages of the appraisal when the house had a biased appraisal within it. It's typically at the sale of your house when you realize your house was appraised longer. So can you kind of dive deeper into why this statute of limitations is something you guys are looking at, and what do you think the impact on the black community? That a whole institution has done a study that talks about $156 billion in lost generational wealth.
Thank you, Senator, for that question. I can tell you that there is a lot being done right now to address that issue, and it's mostly an issue of structural inequities in the real estate markets. And many of those inequities are the result of policies from many decades ago, like redlining, like exclusionary zoning, like discrimination, so on and so forth. And we're still living with the legacies of those very bad policies. And there are steps that are being taken right now to address those issues. I can tell you that from the appraiser's perspective, all appraisers in the country now are required to take at the outset 7 hours of continuing education on valuation bias and fair housing issues. And then they're also required to take a class every 2 years of 4 hours in length as a refresher course. There's a lot of other things that are going on in that space. the Appraisal Foundation has made extensive modifications to the USPAP ethics rule to make it perfectly clear as to what the appraiser's responsibilities are and what they are allowed to do and what they are prohibited from doing. So this issue has been addressed. It's continuing to be addressed. And I think that you're going to see, a lot of changes being made to bring equity into the real estate markets.
And that's fine. I'm happy to hear that there are changes being made. And changes being made now doesn't always equate to the actual change taking place. It's being made. There's some progress moving forward. What do you see as of right now, based off the changes that you guys have made? Any increase in appraisals for black homes within the state of Maryland? And I'll say this: the SDAT guidebook is very clear in how it addresses the value of property. The closer your home is to water, the closer your home is to an urban center, the more valuable your land and your property is. In Prince George's County, we got our homes that are closer to water that are undervalued in comparison to homes just in Montgomery County or in other jurisdictions, or our homes that are closer to the DC line, which we consider our inner beltway communities, which takes you literally 5 minutes to get to the White House. But those homes are some of the most undervalued homes in the entire Washington metropolitan region. Mm-hmm. How do you, and that community is majority black. Right. How do you see, based off of the changes that you've been seeing with your changes that you've implemented through your organization, how many homes have you seen increase in value?
Right. I can tell you that those changes are going to take quite a bit of time to be recognized in the markets. But I can tell you that appraisers, black, white, whatever, are now much more sensitive to the issues related to real estate value inequities. And Delegate Taylor and Senator Hayes have taken this issue and championed it here within the Maryland General Assembly. And Delegate Taylor has some legislation right now that would put in place a process here in Maryland that would allow property owners to challenge their appraisals and to get additional information into the appraiser's hands when there's a reconsideration of value if they're not happy with the value that their property is assigned. And there are some education requirements for consumers. In other words, consumers have to be provided with information related to the reconsideration of value process. And we're anticipating that many of those situations where somebody feels that their property was valued differently because of their personal characteristics, a lot of those cases will be resolved via the reconsideration of value process.
And this, not just those two, it's the entire Legislative Black Caucus, which is the largest black caucus in the country. Mm-hmm. It is a serious issue that this body sees. And out of your own words, you mentioned that it takes time, in order to see, the impacts of these things. If it's going to take time, wouldn't adding a statute of limitations actually hurt?
Your point, Senator, is very well taken. And I can tell you in some of the 16 other states that have considered this issue, they have exempted from the 5-year statute of limitations cases related to violations of fair housing laws and regulations. And I'd certainly be willing to work with you and the committee to craft something very similar for this legislation here in Maryland.
Thank you, sir.
For the gentleman here. About a year ago, we had an appraisal done. Woman's buying all white appraiser. Then 6 months later, we had it done by a black appraiser. There was a $600,000 difference in what each did. I heard you just say that there have been informational and educational things that less or teaching that have that should have made the appraisal situation better. Do you have any statistics from the time you implemented it of complaints? I guess that's all you can go by. Of complaints of racial discrimination between
Sure. I can't speak on behalf of the Maryland Commission on Appraisers, Appraisal Management Companies, and Home Inspectors, but I think the number of complaints that they have received where the allegation was made that the appraiser did something inappropriate based upon someone in the transaction's personal characteristics, I think they have received only a handful of complaints. And I'm not saying, all of those complaints I think were found to be without merit. And I don't know why there would have been the $600,000 difference. You know, I think we can all speculate as to why that may have happened. But I know the complaints that were submitted to the commission, those appraisals were reviewed, and the allegation was found to be without merit. There was also a case in Baltimore City where an appraiser was sued, alleging that their by the property owner, alleging that their property was undervalued. Very, very well-known case because it involved two professors at Johns Hopkins University. But the other thing that's going on right now nationwide is a very, very strong recruitment effort. And Delegate Taylor, again, has a bill in the House of Delegates on this. Strong recruitment for people of color to come into the profession so that there are black appraisers in Prince George's County who can go into black-owned homes and perform the appraisals. And somebody from, 50 miles away isn't coming to value that property. And that person would know the market dynamics in that area. I think diversifying the profession is going to go a long way towards helping to rectify some of those issues.
Thank you. Thank you, Mr. Chairman.
All right. Further questions from the committee? Seeing none, thank you both very much.
Thank you, Mr. Chairman. Thank you, committee.
All right, with that, that'll conclude the hearing for Senate Bill 477. We'll now move on to Senate Bill 480. Senator McKay.
Okay, bring the panel, because I got one. Excellent. Thank you, committee. Thank you, Mr. Chair, for allowing me to present Senate Bill 480. We just 10 days ago had a thing called Groundhog Day. If you believe in Groundhog Day, Senate Bill 480 is exactly in the same posture as Senate Bill 711 last year, where this great committee unanimously passed it. And then the wisdom of the Maryland Senate passed Senate Bill 711 47-0. And then you'll ask, well, why is it back here? So we got over to the House, and the chair and the vice chair. The vice chair had a question about it over in ENT. That question has now been resolved during the interim. And we would just ask the passage of Senate Bill 480 to be passed again. Just to recap, it creates a formal advisory board that provides expert guidance to the Secretary of DNR regarding the management and expansion of off-highway vehicle recreation in Maryland. If passed, the act will take effect on October 1st, 2022. The bill ensures that there is a diverse range of stakeholders who represent to provide balance oversight. And it is crafted similar to any other advisory board that puts input into the DNR. And with that, I'll answer any questions you may have, but we can bring my panel list up, please. Come on. Thank you, sir.
Thank you, sir. Good afternoon, Honorable Chairman, Honorable Vice Chairman, and those honorable members assembled here. My name is Jeff James, and I am a registered structural engineer in the state of Maryland and other states and jurisdictions. and I own a structural engineering company that ironically deals with high-rise multifamily apartments and condominiums. So I've sat here all day listening to testimony on that subject, but I work hard and I play hard. And on the weekends, I like to play hard. How many of you all here like to play hard as well on the weekends? Amen. Well, your kids like to play hard too. So I strongly urge you to pass this bill. And I understand business. I understand economic development. And I'm going to bring sort of a different aspect to this bill. So what we're asking for is a voice in Annapolis for the funding through DNR of the trail system development and maintenance. And basically what that involves is off-highway vehicle usage of that trail system. And you might ask what an off-highway vehicle is. It's a Jeep, it's a motorcycle, it's an adventure bike, it's a ATV, or now is also a side-by-side. And how many of you all know what a side-by-side is? Okay, so yep, 2-seater, 4-seater. I'm going to run out of time, but can I respectfully request a little bit more time to finish? Sure. Okay. 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 So
Nope, you're done. She's got to ask you a question, and then you go ahead.
Gotcha. Thank you very much.
You're good.
Thank you, Mr. Chair. Thank you for respecting our time limit. And my question is, would you please finish what you were about to say?
Thank you. That's and I appreciate that consideration. So the main funding, as I said, is through the tax fees for off-highway vehicles. So every time somebody buys a motorcycle, an ATV, a side-by-side, and by the way, side-by-sides are the fastest growing off-highway vehicle in the country. They are safer. They've got a roll cage. You're required to be strapped in. You're required to wear a helmet. And they are more family-oriented for the trail systems. So there's a lot of trail systems in the United States. We have a neighboring state, West Virginia, that has a trail system called the Hatfield and McCoy Trail System. And basically, the Chamber of Commerces of small towns are very intricately involved in the development of these trail systems, as is the state of West Virginia, because it's an economic boom for these small towns. And it would be an economic boom for the primarily the 4 western counties of the state of Maryland, which is where the trail systems are developed right now. But it's also an economic boom for the rest of the state of Maryland if the trail systems can be developed by the DNR, by the Park Service, by the Forestry Service throughout the state of Maryland, so that these small towns that are associated with these tracts of land are getting revenue for people that are coming in from all over the country to use these trail systems. So we're not talking about these little parks where people are going to ride through these parks on dirt bikes and ATVs. We're talking about large tracts of land within the Maryland system, within DNR, within the Park Service, within the Forestry Service, that were primarily used for mining, for forestry, for economic development in the past, where these large tracts of land are basically sitting dormant, and trail systems are being developed throughout these areas so that they can be used as a recreational source. And in the past, when people used to think about off-road vehicles, they used to think about people just jumping on a motorcycle or jumping on an ATV and tearing up the woods. That has all changed. And as I explained to you, I'm a professional business person in the state of Maryland, but I also like to go out on weekends and use the trail system as in a responsible and tread lightly manner. So I'm seeing a lot of families coming out using the trail systems in these side-by-sides. It's an excellent recreational source of weekend activity. So you all are familiar with how DNR regulates the hunting in Maryland, regulates the fishing in Maryland. What we're looking to do is develop the outdoor OHV sport into the same type of system as hunting and fishing. Does that make sense to everybody?
No, it does. Thank you. That's good. Thank you very much.
So
I think we've got one question for the senator.
Yes.
What was the question that you were that was answered by the vice chair or the chair over there, or whoever the member over there that you've answered? If it's been resolved, that's great. I was curious.
It's been resolved.
Great. All right.
And I'll just leave it at that.
Okay, I appreciate that. Okay.
It's been resolved. That's the important.
Hold on. Let's see. Senator James has a question.
Thank you. Thank you for a lovely presentation.
Thank you.
You're right about one thing, which is that the complaint has been in the past, and I haven't kept up with this, but that some of these vehicles or how they're used, I don't know which, could be, have been tearing up trails. And I'm familiar because I'm a lawyer and I had a case involving this. So how is it, you said that is something of the past and things are great. Just briefly, could you explain how it is no longer threatening the integrity of these trails? Because, motorized vehicles, some people have been very, very hard on them and undermine them for the rest of the public that don't use those vehicles.
Yes, ma'am. Thank you. That's a great question. And if we're related, I would be honered. We share the last name.
I think it's a good name, too.
I do as well. So that's an awesome question. And that is, let me take you back a couple of steps. A 15-year-old boy says, "Dad, I want a dirt bike."
Yeah.
And the dad goes to a dirt bike dealer and says, "Hey, I want to buy my son a dirt bike. And wow, we like this green one over here. It's really neat looking. And let's go ahead and put it in the back of the truck and take it home." And then the son says to the father, "Dad, I got this great dirt bike. Where do I ride it now?" And the dad says, "Oh, well, let's just find a tract of woods or someplace where we can just, take it out and you can have fun on it." So that's where the issue used to start.
Okay.
In that there was no sanctioned area for the operation of a vehicle that the father just bought his son. And the generation of the trail system throughout Maryland creates regulated areas where you have to be permitted to ride, where you have to ride in accordance with the rules of that trail system, and it's also governed by the Department of Natural Resources Police. So you're providing a place for the use of that vehicle that the father bought the son or the father bought the daughter, and they had no idea where to ride it, so they just went out and haphazardly picked a place to ride it. So you're not only providing that trail system, but similar to the hunting regulations and the fishing regulations in Maryland, you're also providing usage regulations on how to respectfully and safely use that vehicle. And
Excellent.
Permitted use of that vehicle.
All right, thank you.
Thank you very much. That's great. Thank you. All right. Seeing no further questions, thank you both very much. Thank you.
So I have one more thing I'd like to add, if I could.
We've got that's a good one. All right. Thank you very much. With that, that'll end the hearing.
Let's go right ahead.
And then we'll go on to Senator Henson, the last bill of the day, with Senate Bill 487.
Thank you, Mr. Chairman. May I bring up the panel as well? Yes. Thank you. I believe there's some folks here. Hi. Hi, colleagues. I'm Senator Shanika Henson, for the record, here to present Senate Bill 487, Motor Vehicle Speed Monitoring System Safety Corridors, the Vulnerable Road Users Protection Act of 2026. Chairman Smith, Vice Chair Waldstreicher, and members of the committee. For the record, I am Senator Shanika Henson, representing District 30 in Anne Arundel County, and to the members of the JPR Committee. Thank you for the opportunity to present Senate Bill 487, Motor Vehicle Speed Monitoring System Safety Corridors, Vulnerable Road Users Protection Act of 2026. This bill is designed to advance Maryland's Vision Zero goals to reduce serious injuries and fatalities on our roadways. By using speed monitoring systems to effectively reduce speed on high-risk corridors where vulnerable road users are present, its primary goal is to improve safety for vulnerable road users such as pedestrians and cyclists. According to National Highway Traffic Safety Administration, the likelihood of pedestrian fatality increases dramatically as rates of vehicular speeds increase. For example, a pedestrian has an 85% risk of fatality when struck by a vehicle traveling 40 miles per hour or over. The most vulnerable road users today are members of our family, our friends, and our neighbors, and we must use every tool made available to us to ensure they are safe when using our highway system. This bill authorizes the State Highway Administration or our local jurisdiction with enabling legislation to operate speed cameras on high-risk safety corridors identified in the federally required and data-driven Vulnerable Road User Assessment. Similar to the Work Zone Camera program that SHA operates, revenues collected from this program will pay for the operational cost of the new program. Any additional resources will then be directed to projects and programs that improve highway safety across Maryland. Contents of this legislation also establish clear guidelines for the use and operation of speed monitoring systems on safety corridors and ensures they are placed strategically in coordination with appropriate local jurisdiction. At this time, I'd like to introduce Will Pines, Maryland Safety Highway Administrator, who will walk us through the specifics of this legislation and the program in practice. After hearing the following information, I urge you to give this bill a favorable report and thank my staff, Linda, for writing this testimony. Thank you.
Well, thank you, Senator, and good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the committee. For the record, I'm Will Pines, Maryland State Highway Administrator, and I'm here today in support of Senate Bill 487. I want to thank Senator Henson for her leadership on safety. MDOT is serious about safety. This bill authorizes the use of automated speed monitoring systems on state and local routes identified as highest risk in our vulnerable road user safety assessment. The bill also authorizes local jurisdictions that have local enabling legislation to use automated speed enforcement in these safety corridors. SHA will consult with these local jurisdictions regarding the appropriate placement of cameras to both ensure appropriate placement at dangerous locations and avoid redundancies of camera placement under other camera programs. To align this program with previous legislation, this bill includes data privacy protections that were passed last session, as well as the tiered penalty structure that also passed last session. Furthermore, the fines collected through this program will be processed in the same manner as they would be for all other state-run automated enforcement programs. For reference, vulnerable road users are defined as non-motorists like pedestrians and bicyclists. These highway users are considered vulnerable because they are more likely to be seriously injured or killed in crashes. Statewide in 2023, we had 621 people on Maryland roadways that tragically lost their lives, and 181 of them were pedestrians and bicyclists. Jumping ahead, between 2023 and 2025, the number of deaths to pedestrians has dropped by 33%. And while we're encouraged by this progress, we know there's more work to do to continue bending the curve towards zero. These are not just stats, they're 439 families impacted forever on Maryland roadways. I ask for a favorable report.
Chair Smith, members of the committee, my name is John Corrin. I'm with Bicycle Advocates for Annapolis and Anne Arundel County, but today representing a coalition of Bike Maryland and a statewide group of bicycle and safety advocates. I want to thank my own Senator Henson for sponsoring this bill and our partners at MDOT for sponsoring the bill over on the House side, which was heard earlier today. I also want to acknowledge that Dan Langenkamp, who many of you know, is here with us today. Dan lost his wife, Sarah, who was killed by a truck driver while she was biking home from her children's school a few years ago. And he is in support of this bill, and I think has sent in written testimony. Walking, biking, use of assistive devices, micromobility devices is absolutely vital for traffic reduction, for promoting health, for protecting our environment, for having a stronger economy, and for making life in Maryland more affordable. But we've got to keep making it safer. As Will gave you some stats, about a third of the fatalities last year were vulnerable road users. It's way disproportionate. We've got to make it safer in keeping with Vision Zero and the Complete Streets policies of Maryland. Intersections are some of the most treacherous places for people traveling on foot and bike, often having to cross state roads. This bill will make it safer for people traveling either along the state road or needing to cross the state road. Automated traffic enforcement is a proven safety countermeasure, as has been heard. The proceeds will go back from this, will go back into safety. Please pass this bill so that we can save more Maryland lives and make it safer for people to travel on foot, bike, and other micromobility. Thank you.
Chair Smith and members of the committee, SB 487 saves lives. This bill reduces crashes where the risk is highest. It gives Maryland the authority to slow vehicles in exact corridors where people are most likely to be seriously injured or killed. I'm Michael Sakata, President and CEO of Maryland Transportation Builders and Materials Association, and according to Maryland's official crash dashboard, zerodeathsmd.gov, our state recorded 475 fatalities in 2025. Definitely a decrease from the previous years, thanks to a bill supported by this committee and this legislation. It included, in 2025, though, 95 pedestrian deaths. That's 95 families whose loved ones did not come home. Federal Highway Administration considers fixed speed safety cameras a proven safety countermeasure. FHWA reports that the fixed unit speed cameras reduces crashes on roads up to 54%. If Maryland's highest pedestrian corridors experience reductions approaching that level, that'd be about 50 lives per year. That's nearly 3/4 of a school bus filled with children. That's the scale of prevention we're talking about. This bill does not authorize blanket enforcement. It deploys a proven safety tool in corridors Maryland has already identified through crash data as high risk for vulnerable road users. I represent the men and women who build Maryland's transportation infrastructure, the roads, bridges, intersections, and crossings that connect people to jobs, schools, and family. Infrastructure matters, design matters, investment matters, but none of it can overcome reckless speed. And if this were about money, we would deploy cameras where traffic volume is the highest. This bill does actually the opposite. It limits enforcement to corridors identified through when crash data as dangerous. When a proven safety tool can reduce crashes by more than half at treated locations, the responsible course is to use it. Thank you.
Good afternoon, Chairman Smith and members of the committee. For the record, my name is Chris Lawson, and I am the Government Relations Director for the Maryland Transportation Builders and Materials Association. I am a lifelong Marylander, and before joining MTBMA, I served 31 years with the Federal Highway Administration, working in various capacities to include transportation safety, as well as project delivery. Over 3 decades, I saw firsthand how crash data shapes policy and how federal and state agencies partner to reduce fatalities. Speeding remains one of the most consistent contributing factors in fatal crashes nationwide. Here in Maryland, more than 7,700 crashes in 2023 involved speeding. That is not an anomaly. It is a pattern. At FHWA, we relied on data-driven countermeasures. Research consistently shows that automated speed enforcement, when used in documented high-risk corridors, reduces crash severity and changes driver behavior. What is compelling about this bill is that it makes a meaningful connection between Maryland's vulnerable road user crash data and proven safety tools. It does not authorize broad expansion. It ties deployment to identified corridors. It includes privacy protections adopted last session. It aligns with the tiered penalty structure passed in 2024 under the Road Worker Protection Act. As both a transportation professional as well as a lifelong Marylander, I believe this is responsible, data-driven policy. Targeted enforcement in documented high-risk corridors saves lives. We respectfully request a favorable report.
Thank you, Mr. Chair. Thank you, Administrator, and everyone for being here. And Administrator, thank you to you and your team for working with me and including so many of the things that you did. Out of curiosity, I was reading the 23 USC 148 to find out what exactly went into the vulnerable road user safety assessment. And it's interesting. So I gather you all have done all that with the most recent 5-year data and all of that. So how many cameras would you anticipate SHA looking to install based on the assessments that you've done?
So the overall, the vulnerable road user safety assessment identified the bill that came last year. There were 89. The updated report has 91 corridors. Some of those corridors were added based on the feedback from local communities. The process that we undergo includes a public engagement process. We had an open survey for about 3 months, which ended in August of 2025 to collect feedback about the corridor needs statewide and where the most dangerous areas are. Intuitively, I'll say that many of the corridors, I think, are really things that should be of no surprise to any of you. Maryland 528 Coastal Highway in Ocean City. You can imagine that's a corridor that has a lot of issues and fatalities that occur. And so what the report did, we actually broke up the entire state, excluding roads that have pedestrian prohibitions, and then broke each of those corridors up into segments. They vary anywhere from about 1 mile to at most about 5 miles, but they're really identifying just the areas by segment that have high crash, high fatality rate, serious injury crashes to pedestrians and bicyclists, et cetera. We take that data, then again, go back out to the public, get input in on it, and then that helps us to refine the corridors, to remove those that were deemed lower risk. And so what's those 91 corridors that are left are the ones that we have identified as the highest risk in Maryland.
Got it. Thank you very much.
Thank you.
Thank you, Mr. Chair.
And thank you, Mr. Bryan. Good to see you. We've been talking a lot, and I deeply appreciate your being so responsive. As I look through the file, the only opposition I can find is from my own county executive. But it's not clear to me what the meat of his opposition is, so I am certainly going to reach out to him. One of the comments he makes is that local governments are best positioned to evaluate where enforcement tools are appropriate. It is my recollection that you've advised me that Harford County was involved in your public outreach, and various government representatives acknowledge that the 3 roadways that you've identified, the sections of the roadways, are the ones that fall under the category of vulnerable highway sections and people are at risk of getting seriously injured. Is that correct?
Correct. Let me give a little bit longer answer, if I may.
Sure. Yeah,
one thing I'd like to point out is there is another letter of opposition that I want to acknowledge. Okay. That's actually from the district court.
Oh, yes.
We're working
I was going to ask you about that.
Yeah.
If you just wait a moment. Yeah, I was going to ask that next.
And so we're working, I ran out of time with my 2 minutes, so I want to make sure I say this.
Sure.
We're working very constructively with the Chief Judge on a friendly amendment. Last year, there was a camera bill on the ICC that added the word uncontested citations to the section of the code. We have no concerns whatsoever with removing that, and have offered friendly amendments to that. I think
Well,
we're
that
okay
didn't
there.
answer my question,
So,
but I was.
I'm going to your.
He's not my first one, but my third one was going to be to address the courts. Yeah, because I can't imagine you want to burden the district court. But it does kind of dovetail with my second question, which is the blanket statement in the letter is just that it may create operational administrative burdens on the county, including signage, public outreach obligations, citation process, and coordinating with state agencies. Briefly, do you want to comment on whether these concerns are in fact ones that I should be concerned about, or is my county executive maybe perhaps not understanding how this bill works?
So I think there is some of that, but ultimately, we listened last year. We heard that there were local governments that had concerns about the bill and that there were a lack of constraints on and requirements around collaboration. So I want to point out that on page 13 of the bill, there are provisions that require us to consult local governments to make sure that they're involved in the process. And also to Senator Love's point about potentially having too many cameras, we actually have to coordinate with them on the locations to try to reduce redundancies. We don't want to put out a camera on top of their camera, and we realize that that creates a lot of problems for a lot of folks, and we're not interested in that. On the operational concerns, there were comments made in the letter about the county being required to pay for signage, et cetera.
Public outreach, citation process, coordination with state agencies, and other burdens.
That only applies if the local jurisdiction would elect to administer the program.
Okay.
Consistent with all state camera programs, if the local government administers it, then they install the signing and the, process the back office and everything associated with it.
But they'd also get repaid from.
Correct.
because
They
they'd be
would
the
receive the
primary
revenues
recipient
from
of
the program.
of
That's
ticket.
correct.
So, again, maybe not a complete understanding of how the bill works. And then the last comment they make is that roadway safety is best advanced through engineering improvements, target enforcement by sworn officers, public education, and locally driven safety programs. I would note that the Sheriff's Association, of which I'll check with my sheriff is a member of it, they support the bill as which is good. Can you just briefly perhaps respond to why perhaps engineering improvements, public education, and local programs may not or have not already brought down the alarming number of accidents in these vulnerable corridors, 3 of which are in Harford County, all 3 of which I'm familiar with?
Thank you for that question. So statewide, we just earlier in the week announced 5 additional pedestrian safety action plan corridors. That brings us to 18 total that we're making very significant investments in.
Okay.
However, as I mentioned, there's 91 corridors. So it's tough to build your way out of the fatality problem as quickly as we need to. As was mentioned in many of the remarks, these are proven safety countermeasures that are evidence-based, research-based tools to save lives. We last session, House Bill 182 passed, which required State Highway to form a work group and evaluate all of the existing local school zone programs statewide. From that evaluation, every county provided us data supporting that speed safety cameras reduce speeds, reduce crashes, and ultimately over time have citations reduce. People become aware of where the areas are that they need to slow down, and they adjust behaviors to that. We've also seen that in our work zone program, where our work zone camera program has seen reduced citations over time.
So let me just, last question for now, and I know that you will continue to work with me, and I'm certainly going to reach out to my county executive, because I'd like to get a consensus here. What would trigger because these are not going to be cameras in perpetuity. First of all, probably because at some point people figure it out, right? But what triggers your removal of the cameras? I see what prompted them, when do you feel that they've been the most effective and that they do not remain a permanent, they don't intend to be permanent, I assume, is that correct, these cameras?
So as you talked about, there's 4 E's of safety. Enforcement is one tool, but infrastructure improvements with engineering are another. Obviously, when we make substantial improvements to a corridor where the enforcement needs may reduce, because especially where we're able to install traffic calming devices that help to slow down naturally, that's an ideal case, but we've got to make the investments in the corridor to get there.
Okay, but there, again, are these cameras to be permanent, or is there a trigger for when they would be removed?
I think it would really depend on the safety need. If we put in other measures that were able to help slow folks down without the camera, then we would not keep it in place.
And I'm sorry, one last one. I think in the work zones, we insisted that there be a lot of public outreach, a lot of notification, you know, this is coming, you'll be on camera. Eventually, you're not going to get a notice, you're going to get a ticket. Is that part of this program?
All of the same signing and notice requirements that are in the work zone program and other safety speed monitoring programs are consistent in this bill. We tried to match the other bills as much as possible to not have deviations that would be alarming.
All right, thank you.
Thank you, Mr. Chair. Thanks for coming today, Will. Good to see you, Mr. Pines. So just a couple really cleanup questions. The signage, I noticed that it says that it would be a conspicuous road sign is placed at reasonable distance consistent with the national guidelines, but it doesn't specify, like, I mean, are you talking about the size of the sign is consistent with national guidelines, or the distance prior to the VRU area would be consistent with the guidelines?
So we utilize for signage the manual for uniform traffic control devices. Yeah. This is actually adopted in law that we're required to use that. We're actively working right now to have that approved by Federal Highway, the updated version. We will follow that in the placement of signing. Frankly, we've got a long track record with our work zone programs of putting out advance notice signing. We're going to do similar things to that.
Yeah, and I like the numbers I saw after, you know, the work zone safety results over the past year with the reduction of crashes in work zones. But there was a lot of work that went into that as far as making it about safety and making sure that people were readily aware that they were entering into a very you know, restricted zone, tighter zone, whatever you want to say, lane widths, construction zone. Are any of these funds, when I guess you said like a couple other municipalities reached out to you or counties, someone asked you, you added, it's now 91 locations. Is that right? That you would be under consideration as VRUs?
The 91 locations are the locations on state routes. If you include local jurisdiction routes, primarily Baltimore City, it's 135.
Yeah, no, I'm not including those. But when it's the state routes, is there any share with the local government that's asking, or is it all the revenues go back into the state?
Currently, the bill is drafted really goes to whoever is administering the program and bears the cost of running the program receives the revenue. So if after we follow the requirements of coordinating with the county, if they, using a first right of refusal process, if they don't want to do a camera but we're open to us doing it, then we would install it and we would receive the revenues. Those revenues flow down for system preservation and highway safety purposes only. They're limited to that purpose. But if the county were to administer the program, the county would also receive all of the revenue.
Okay, thank you. And then my last question is, was there, you know, much like we did with the work zone, where we made it more meaningful should there be workers present, is like, are these areas, and I know we spoke about like school zones, you spoke about that briefly, but these high, I guess, pedestrian areas, is there any consideration that if there is any pedestrians or vulnerable road users in close proximity to a violator, of making the fine higher?
We would be open to ideas there, I'll say. Currently, The last session, there was a bill that passed a tiered fine structure, and again, we really tried to replicate. We heard you say there's disparate ideas for how to do this, and so we tried to match what's already in law as much as possible.
And I appreciate that. I mean, I was one of the ones that worked on that. I think that we came to a meaningful, outcome as far as finding a solution that was meaningful but impactful, and I think that's shown in the data so far. So, as far as work zones, but thank you for your answers.
Thank you.
All right, seeing no further questions for the panel, thank you very much.
Thank you.
All right, let's bring up the next panel. The Anthony Management Group, is Anthony here? Okay, and then is Mary Ellen Tokar, that's it, Mary Ellen's here, and Janet Gronke?
She's not here.
Okay. And then we have one person. Is there anyone in the Zoom room? All right. And Mindy, we'll get to you, but go ahead, please.
Chair Smith and members of the committee, thank you for your time today. I'm Mary Ellen Tokar. I'm with Maryland Transportation Builders and Materials Association, MTBMA. As the government policy director at MTBMA, I review transportation legislation every session. I believe that this bill is important because it aligns policy with data. As you know, this bill will authorize speed monitoring enforcement on roads identified as high risk for vulnerable road users. So these are pedestrians, cyclists, and non-motorists. Speeding is a factor in roughly 1/3 of traffic fatalities nationwide, and the relationship between speeding and survival is exponential. When vehicle speed increases from the low 20s to the 40s, the likelihood of a fatality rises dramatically. Research also shows that automated speed enforcement in high-risk corridors can reduce crashes by 20 to 40%. That is measurable impact. In 2024, the General Assembly passed the Maryland Road Worker Protection Act, recognizing that higher-risk environments require stronger prevention methods. And in 2025, Maryland recorded a decade low of highway fatalities. While I cannot stand here and state conclusively that it is cause and effect between the legislation and saving lives, there is an undeniable correlation. Structured enforcement and data-driven methods work. This bill builds on this model. It is limited to roads identified through the state's vulnerable road user assessment. It incorporates privacy protections adopted last session and a penalty structure already implemented statewide. This is not broad expansion. It's legislation with a direct link between documented risk and provable outcomes. MTBMA strongly believes that this bill will save lives, and for this reason, we respectfully request a favorable report. Thank you.
Excellent. Thank you very much. All right, Ms. Baden, Mindy, you're up. Welcome.
Oh, thank you very much. I'd like to thank the committee for giving me the opportunity to speak here today. In January of 2020, my son Brett was killed while he was crossing the street. He was doing what just so many people routinely do every day. And now my family is forever changed, and my broken heart will never be healed. The road where Brett was killed is part of a high injury network, a roadway where a disproportionate number of serious crashes occur and pedestrians and bicyclists are at a heightened risk. Speed is one of the most significant factors in both the likelihood and the severity of crashes. Even small increases in speed dramatically raise the risk of death or serious injury. Speed cameras are a proven tool to address the speeding problem. Drivers respond to speed cameras by lowering their speeds, resulting in fewer crashes and fewer deaths. Under current law, many of the roads most in need of speed enforcement are ineligible for speed cameras, despite safety concerns. Senate Bill 487 would correct this gap by authorizing the State Highway Administration and local jurisdictions to use speed monitoring systems to create safety corridors. This bill takes a proactive approach to improve safety for vulnerable road users and holds motorists accountable for reckless driving and speeding. Senate Bill 487 will save lives by preventing crashes, and it will spare other families from the pain my family lives with every day. Please give SHA and local governments the ability to slow traffic on the most dangerous roads before more lives are lost. I urge the committee to issue a favorable report on Senate Bill 487. This legislation will prevent injuries, save lives, and make Maryland's streets safer for everybody. Thank you for your time and consideration.
Thank you, Mindy. On behalf of the committee, just want to say we're obviously sorry for your loss and want to say thank you for waiting all day and hanging in there with us to engage. Really appreciate you taking the time, and thank you for that. And again, condolences for your loss. Thank you, though.
Thank you.
Have a good afternoon.
Thank you.
All right. With that, that'll conclude the testimony for the proponents of the bill. We'll now hear from Chief Judge Morsi, who is signed up in opposition.
Good afternoon, Chairman and members of the committee. I recognize that I am the last between you and in the evening, so I'll.
No, we've got voting afterwards, Chief Judge.
Oh, good. Then I can take my time. Is that what you're telling me? I'd first like to acknowledge Administrator Pine, and we've been working since last year. As you know, the judiciary tries very hard not to take positions on policy, and in fact, that's where the problem came in, because last year there was a bill. It involved the intercounty connector and additional cameras on that. We viewed that as a matter of policy for your discretion. We did not get involved in it. I will mea culpa say that our team did not catch 3 words in that bill because it appeared just to be an additional cameras. Those bills were or uncontested cases for the MTA. That would take, we handle all the contested cases, not only for the MTA, but for all the local jurisdictions. We're good with that. We have a defined business policy. We're handling it. It's not really requiring, we've absorbed it into our day-to-day functioning. When it came to uncontested, we don't actually know how many citations are issued by these providers because each place has their own little provider, right? We only get the contested cases. And so it went on an order of magnitude from approximately 6,000 MTA cases that we were going to handle to 300,000 cases. And we were going to have to develop some new type of system to accomplish getting those electronically to us. We have the case management system, but we don't have a front end for them to do that, nor did we ever handle any of the payments of uncontested cases. So it's not just the communication vehicle, but how we set up payment things. I'm pleased that in working with Administrator Pine, they've agreed to a friendly amendment that would remove those 3 words from this bill. The reason I'm here too also is because this bill carries through to other bills that you're going to see about these camera cases. So we've submitted basically a fiscal note that would say this is what we are just guessing that it would take us to stand this up. It would be a multi-year project. I'm still very interested in looking at an external interface for accepting these cases, but it can go in our normal business process that we have for evaluating new technology programs and trying to fit that into where that goes in our budget and all the other projects that we have going right now. So I hope that makes sense to you all. I appreciate the cooperation with our partners at MTA. We deal with the MBA and MTA very extensively, the reporting that we do back and forth. So that's why I'm here. So it's not really a formal opposition. It was just please remove those 3 words, and I'll be very appreciative to you guys.
So we can just take it as you're opposed?
I'm just kidding. I wanted to come to show that we can say that we're support with favorable amendment, I think might be the term, right? I don't even know how to say those words. I shouldn't be saying that, but. And thank you all that were on the Senate. Oh, I'm sorry, Senator.
Judge, thank you so much. I want to make sure we heard you properly. We are looking at more and more cameras, and we are involving the district court. So you are letting us know, or you will let the budget people, and certainly the governor, when we are starting to add to your budget in a way that your budget is not ready to accommodate, is that a possibility that we should just be mindful of so that we consult with you fairly regularly?
Exactly, but we actually, because we were in panic mode, we didn't, no one realized this until late summer that there were these 3 new words in. And so it was all out of panic mode, and I literally did not have the capability to undertake it, and that's why we've worked with the MTA to develop a program that we can accomplish what the law says for the time being, but it's not a sustainable thing. If we just go back to contested, we're okay. It is going to, you know, with all these other bills that are coming
what I'm
through,
saying.
it's going to increase capacity. But if we do it the right way through we have a pretty sophisticated model of approving these type of projects that will put it into our pipeline. I need to get consensus from the other people that I work with
Right.
that it's a viable project and that it's worth us doing it, and then funding from them. But it's doable.
Right now, you're keeping up with us as long as we don't.
Exactly.
Put the uncontested.
We actually looked at, we have an e-TICS program that the Maryland State Police created in conjunction with us to take all the regular citations that the police issue. And that works very well. And we thought maybe we can leverage that technology, but that's person-based. It's issued to a person. This is issued to a car or a registration. So and that technology is old. So we'd have to, if we're going to do it, we need to rewrite it all up into modern code anyway.
Well, thank you for bringing that to our attention.
Thank you very
Appreciate
much.
it.
And my only question was that it seems like from the fiscal note that it seemed like you were struggling to keep pace with the current workload and that you were going to need to invest $1.4 million just to keep pace with what you're doing now. I'm trying to understand if are you already kind of at the over limit right now, or are you?
No,
for capacity? Okay.
we can, for the foreseeable future, we can keep the current business process the way it is, but eventually we're going to have to go to a better system, you know, just a more sophisticated system than we have. But those are the kind of things we do in the judiciary all the time. We're constantly evaluating new technologies that comes in and trying to implement it. Let me knock on wood, this weekend we're taking the next version of MDEC. It's MDEC 2024.
Nice.
That has programming that we've been asking for our developer for a number of years right now. If you know how prior technology project, at some point your cell phone says it's no longer going to support version 5 and you have to take version 6. They won't put development into version 5 anymore, so they kind of force you to go to version 6. But we're really looking forward to it because it's going to improve system performance, and it's part of a routine to keep that system green. And I'd like to thank the members of this committee that were on the Senate Nominations Committee. It was a very pleasant night. My wife was extremely impressed at the work that you did, and she said, how can they stand sitting there listening to you draw on and on? Literally, she said that.
God bless. See, there you go.
If there's no further questions.
No further. Thank you very much.
Thank you very much, members.
Thank you. All right, with that, that'll conclude the hearing for Senate Bill 487 and the hearings for the evening. We're going to gavel out with the reset, and then we will commence voting 5 minutes, and we'll do our level best. All right.